Honorable Justices of the Appeals Court, now sitting in Boston, far and within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Come on, Your Honors.
Good morning and welcome to the Appeals Court. I'm Judge Milkey. To my right is Judge Hodgens, and to my left is Judge Toone. And we are your panel for the 6 cases we're hearing today. Most of you arguing today are veterans of the court, so you know the rules, generally 15 minutes per side. No opportunity for rebuttal. Generally speaking, 15 minutes is not a great deal of time, so we urge you to cut to the chase to the extent possible. And we are very happy to help you do that with questions as well. On the other hand, if you feel like you have said all you have to say, there's no shame in sitting down early. As one of my former colleagues used to say, if you hit a home run, there's no reason to run the bases twice. And with that, I will call the first case of the day, 2021 P1129, Commonwealth versus Regan.
Good morning. Good morning. May it please the court. Joanne Petito for the defendant, Mark Regan. This case relied on a warrantless entry into the defendant's home, which violated his rights under the Fourth Amendment and Article 14. The entry was justified by the motion judge under the emergency aid exception to the warrant requirement, and that finding was clearly erroneous. The judge relied largely on the fact, on a purported medical history, medical issues, and his age. However, there were no specific or identified or even real evidence of an emergent medical condition that was provided to the police prior to their entry. The decedent's brother was even at the home prior to the entry, and he didn't even tell the police that there was any medical concern. In addition, his age was, as related to the police prior to their entry, 58 years old, which is not a person of significantly advanced age. To say that there was a vague statement by the 911 caller that said he had some medical issues, to say that a 58-year-old man has some medical issues could likely be true in any case. It doesn't, for any individual. It doesn't give rise to a concern that the individual might have suffered a medical, a medical emergency.
But let me ask you this, because the touchstone of the Fourth Amendment is reasonableness, right?
Yes.
So if you have a situation where mail is piling up, the snow and ice piled up in the car, the neighbors say there's been no activity, and the police have had not just 1 but 2 requests to check on somebody in the home, what would be a reasonable response of the police in that situation?
Well, actually, the standard to enter without a warrant is an objective belief that someone is injured or in imminent danger of immediate physical harm. That doesn't give an indication that there's a person who's been injured or that entry is needed without a warrant to prevent imminent physical harm. There could be additional facts gathered, additional investigation that could be pursued, and the police could go get a warrant. There wasn't any indication here that there was a time concern or...
But the warrant would be a belief that a crime has been committed, though, right?
Yes.
But we're not dealing with that. We're dealing with, people who are very concerned about somebody living in the residence and they haven't heard from this person for a period of time. So there's not going to be grounds to get a warrant. So that's why my question is, what, with this information in mind that the police have, a possibility that someone is unconscious or has fallen, might need medical care, has been unable to summon aid, what would be the reasonable course of action for the police in a situation like this?
Well, when I suggest additional investigation, what I suggest is that additional facts could be gathered that at some point, if entry were deemed reasonable, a warrant could have been supported. The thing is, this is an individual's home, and that's where the Fourth Amendment interest in privacy is strongest. In other cases where there have been missing person reports, there generally are additional factors which support entering the home, such as there's domestic violence. In fact, in the case that the Commonwealth and the motion judge compared this case to, there were many, many factors that were not present in this case. That was Townsend. That was a case, for example, where there was a history of domestic violence between the missing individual and the defendant in that case. She was last heard from when she was in that person's home. She was known to binge on cocaine. And there was a very concerned individual who had related all of that information to the police prior to their
Did the police,
entry.
I'm sorry, did the police in this case know about a contentious relationship between the victim and the defendant?
No, that was testified to at the suppression hearing. The decedent's brother testified to that, but the police officer who entered, Officer Parento, testified that he was not even aware that anyone had been at the house prior to his arrival there that morning, which was in response to a second 911 call. So all the police, so they did not know that there was an individual living in the house who this witness described the situation, the relationship as tumultuous. So, and that was not known to police prior to entry, at least.
Okay, but they did know of generalized medical issues, right, without any specifics, but there was some information that there was a potential medical concern.
Well, there wasn't, what the evidence was that the caller said that he had a couple of medical issues, and that was the extent of it, and there was testimony at the suppression hearing from the officer, again, that said, we were told he had a medical history or a couple of medical issues, but nothing specific at that time.
So what in your view is like the required level of information that's needed to sort of justify the medical aid emergency exception?
If it's based on medical reasons?
Yes.
If it's based on medical reasons, you should at least know what the medical concern is. What is the medical concern? I mean, having a couple of medical conditions could be any medical condition.
You need some specific medical problem to be identified?
Not even a specific medical problem, even if there's information that, I know this person has a lot of medical problems, they've been rushed to the emergency room before, maybe there's this one or two, maybe there's an identifiable medical issue, something that suggests that the person is in danger of having an emergent
Why
medical
isn't the
situation.
concern expressed by the employer and the brother enough, where, after a regular history of showing up at work, he's suddenly AWOL? Why isn't that enough to have a reasonable fear for his safety, even apart from any knowledge of medical conditions?
Well, again, it's generally based on the totality of the circumstances, and in this case, because we're talking about entering someone's home, there needs to be a definable, at least a reasonable basis for an objective belief that there is actually an imminent danger of physical harm, or there has been an injury. So there should be something specific, something in addition to the fact that he hasn't shown up at work for a couple of days. And just in looking at the cases that are where entries have been upheld, there generally is an additional circumstance like domestic violence, like a likelihood of possible drug use, the possibility of an infant in the home alone, which was present in the Entwistle case, a pampered family dog that's just been left alone for a couple of days with no arrangements made. Those are factors in addition to the fact that this person hasn't been able to be reached by family or friends.
You're not, I'm sorry, you finish.
No, that's fine.
You're not arguing that the emergency exception doesn't exist after Caligula?
No. What doesn't,
Like I'm reading Justice Kavanaugh's decision. He says, like, elderly man uncharacteristically absent from Sunday church services, fails to answer his phone throughout the day and night, concerned relative calls the police, asks the officers to perform a wellness check. 2 officers drive to the man's home, they knock but receive no response. May the officers enter the home? Of course, right? So he seems to be saying just a wellness check is sufficient to satisfy he calls it the exigent circumstances exception. So you think that our rule should be more restrictive than what he's suggesting there?
well, I mean, I think that case wasn't, the suggestion, that case really was, that was said, but it really wasn't a case about the emergency aid exception. It really was, that was an example given as a contrast of an emergency aid exception.
No, it may not be binding, but isn't it close on the facts to the kind of exigency we had here?
Well, this was not, actually, this person, it is somewhat different because this person was not elderly. The police thought that he was 58. He was in reality, I believe,
It depends on
60s.
your perspective.
Yes. 58, I don't think so. I think he was, in reality, 66 years old. That is not elderly either. In addition, yeah. We're all heading there. He wasn't, and in any event, he was not a frail individual. He was an individual who was, so it's not a frail elderly individual alone. Nobody's heard from him. He was 58 years old. He had a job.
Time is getting short. Would you like to address the fingerprint?
Yes, I would. The troublesome testimony here was that the fingerprint expert testified that he had never made an erroneous identification. That type of testimony
To his knowledge.
I'm sorry?
He had never made an erroneous...
To his knowledge. To his
right.
knowledge. Testifying that an error rate in fingerprint analysis is 0 is not permissible, the Wadlington case.
But he didn't actually say that, correct?
Right, but what he said, I believe maybe there's an argument that it is even worse. He said, for a couple of reasons, he didn't just say this method is error-free. He said, I am error-free. I've never made a mistake. And it also raises the question of, how does he know that? How does he know he has never made...
Did he claim to know that? He said, to my knowledge.
Okay, well, then it's unhelpful and prejudicial, and it does cast his opinion.
Remind me, was there an objection to that?
There was no objection. Fingerprint analysis is solely a matter of opinion. It's not a science. It's to be expressed only as an opinion that basically it's a subjective analysis of, I think this matches, I think it doesn't match. It's offered with no statistics. It has been determined that the results cannot be replicated.
Didn't the expert ultimately frame his opinion as an opinion, maybe at the judge's prompting, but it wasn't, I understand your concern about these comments, but ultimately the opinion was presented
He testified that he testified in the end that he individualized, in his opinion, the print was individualized or identified to the defendant. However, his discussion of the analysis method, in that discussion, he discussed coming to a conclusion of identifying fingerprints to a certain individual. That was not expressed as opinion. He didn't testify, we can opine that this fingerprint can be individualized to this individual. But the overall guideline here is that it's opinion, and it cannot be expressed in terms of infallibility, and the accuracy of an opinion of fingerprint analysis cannot be overstated. So fingerprint evidence is allowed in, but it is subject to those two restrictions.
But what about the instruction from the judge where he said you are to treat so-called expert witnesses just like you would treat any other witness, and he specifically referenced the fingerprint expert So there was nothing magical about his testimony. He was to be treated like every other witness.
Yes, I mean, that's the standard instruction that's always given, and that's true. An expert's testimony is to be treated as any other witness, but this expert testified that he has never made a mistake, suggesting that his analysis is error-free and it's not fallible. The jury can accept that or not, as they do with any witness, but that's what he testified to.
How about the expert's statement that it's never been shown that two people have identical fingerprints, or I'm paraphrasing. Commonwealth points out in its brief that you don't appear to be challenging the truth of that statement. Could you respond?
Well, some people have suggested that no two fingerprints have ever been, no two individuals have ever been found to have the same fingerprint. I do have somewhat of a problem with that because I don't know that that's ever been tested. However, there's a concern with juxtaposing that statement with the type of analysis that's happening here in this case. Latent fingerprint testimony in comparison is comparing a portion of a print to a full fingerprint. That is not the same as saying two full fingerprints from two different individuals can never match. And the SJC has discussed this and pointed this out in some of their cases in Gambora and Joyner.
If I can paraphrase, you're saying regardless of whether or not the statement as such was true, it was misleading.
Yes, it's misleading.
I just want to clarify for the Guadardo, the gun charges.
Yes.
You make an argument that there should be an acquittal, but it seems like in Guadardo 2, the SJC said a remand for potential retrial is the appropriate remedy. You don't disagree with that? That's where the SJC...
I understand. Yes, the SJC, under Guadardo 2, he is entitled to a new trial on those charges, and the Commonwealth doesn't contest that.
Okay.
But in this particular case, because the gun was found in the home, I've made an argument in the alternative that that right was established under Heller.
Okay. All right. Thank you.
So,
Counsel, thank you very much.
Thank
We
you.
will hear from the Commonwealth.
thank you.
Good morning, Your Honors. May it please the Court, Paul Lynn for the Commonwealth. The victim's age and medical issues were not the centerpiece of the judge's finding here. The centerpiece of the judge's finding was this was a reliable employee who had missed at least 3 shifts. His employees couldn't get a hold of him. The police had already gone and made one well-being check the first day, knocked on the door. Nobody had answered. His mail is piling up. His car is present, and it's covered with ice. The neighbors report that they haven't seen any activity in the house. And yes, his employer did report to the police on the 12th, 2 days before the entry, that the victim was in fact 66 years old, and he would know. He's the employer, as opposed to the second 911 call, who was the origin of which was a coworker of the victims, who reported it to his brother, I believe, who was a police officer.
Is the exact age relevant if the police did not know that?
The police did know that.
Oh,
they knew
did.
it from the first call. Now, whether or not the specific officers who showed up and made the entry knew that, but the police collectively had that information. They had it pursuant to the first attempted well-being check.
So what was the emergency then?
The emergency room is, there is objective reason to believe that he is incapacitated.
Just because he's not responding.
He's not responding. He's not showing up for work.
It's a wellness check, right? I mean, you think about emergency aid, you presume that there's some kind of emergency you need to respond to.
Right.
You're just saying a wellness check, if there's a basis for a wellness check, that's always going to be enough to satisfy the emergency aid doctrine.
I don't know if that's necessarily true, but it's certainly true here. I mean, there's no evidence of a crime yet until the police enter. They are strictly concerned with the health and safety of the victim.
But it's all inferential, right? It's all just like,
of course.
He's a really good employee, he doesn't show up, there's mail, there's snow in the car.
Yeah,
Let's go in, right? I mean, there's no sort of really hint at what the emergency was.
Correct. We don't know, and that's in the nature of the emergency exception. We have an inference that the victim is in trouble. He's incapacitated, he can't get to his phone, he can't get to work.
So is any kind of wellness check sufficient to invoke this exception?
I don't think so. Otherwise, there wouldn't be any distinction between
Yeah, so what do you need? What do you need for a wellness? What should the rule be that allows a wellness check to be justified for a warrantless?
The rule is, as my sister pointed out, is that you have to have objective reason to believe that the subject is in serious danger. I don't remember those are the exact words, but that's essentially the standard.
So that's the line between wellness check and emergency?
Right. It's the difference between, hey, are you okay, and something seriously wrong here. And I think the evidence you have here, are all of this put together, the totality of the circumstances, show that something is terribly wrong.
What's an example of a wellness check that wouldn't qualify?
Oh, I think you like I can't remember which case it is where they just go up to the guy's car and the guy's car is running and they tap on the windshield, that sort of thing. That's like, hey, you could just be sleeping, which is a responsible thing to do if you're tired.
Now, you highlighted that there was no evidence of a crime at that point.
Correct.
How is that relevant? Is that because of the potential for pretext?
Exactly, Your Honor. There's obviously no pretext here. Now that's not, I can't think of a case in which that was a relevant factor, but it certainly shows that there was an honest belief by all these people. And that's the other factor that I forgot to mention is, of course, his brother shows up and says, I'm concerned that he hasn't shown up. So you have all this objective information saying that the victim is incapacitated. The victim cannot go to work.
In Townsend, one of the, as your sister points out, in Townsend, one of the factors was this history of domestic violence.
Correct.
So actually, there was a hint of potential criminal
True.
activity. And you're saying here your case is stronger because there is no evidence of criminal activity.
I'm not sure if it's strong, but I think it certainly shows that the police were genuinely concerned. That's the only relevance. Whether that is relevant to the standard is an open question, but it certainly shows that the concern was a genuine concern for.
I get back to it seems problematic to issue a ruling that any kind of wellness check on a home.
Oh, absolutely.
So I just don't know exactly. Most wellness checks have some kind of reason for them. So what distinguishes a normal wellness check from one that justifies warrantless entry?
The evidence that the victim is incapacitated and thus in serious danger. I think that's the big difference.
Can we draw an inference here in this case from the fact that the police actually responded to the residents twice? In other words, the first response, that almost seems like a wellness check. And the second response seems more like now there's an emergency afoot because there's a growing level of anxiety and concern among people who know him.
Exactly, and I think they go to the house the first time. They're like, well, he's just missed one day. We're not going to barge through the door, which was the right thing to do. But now you've got these additional factors. You've got the mail, you've got the car, you've got the neighbors, you've got the brother, and now you have solid evidence that something is terribly wrong.
Does it matter that the person bringing the motion to suppress is not the homeowner? And would it be a different case if they found the homeowner here alive and well with a meth lab inside the house?
Yeah, obviously, but in that case, they'd still have it still would be a lawful entry.
So no, but the same test you're saying?
Yes.
Okay.
Right, and I don't think it matters. That's one thing I thought of when I was preparing this brief is could I make a consent argument? And the reason is, first of all, the police didn't ask for the brother's consent. And second reason is there is some question as to whether or not an owner who is not a tenant who's not a resident of the building has the right to let the police barge in without notice. And the police clearly relied in this case on the emergency aid exception.
Now, you appear to acknowledge in your brief that the police couldn't take into account the tumultuous relationship between father and son. I'm assuming that that's because they weren't aware of it,
Correct, Your
not
Honor.
because it was.
No, it's perfectly relevant. It's just the police were completely unaware of it at the time. Or at least there was no testimony that they were aware of it. The brother didn't say he told the police, and the police didn't say they knew about that. Are there any further questions on that issue? Well, one thing I do want to add is the Commonwealth below and the motion judge relied on Townsend, which I think is a perfectly good case. That's the case with the domestic violence and the drug use. But I think the better case in this, in the Commonwealth's favor, is Entwistle, because in Entwistle there's none of that. You just have concern for the family, and you know again the central issue is the mother in that family is not going to her usual appointments. She's not meeting her mother. She's not calling her mother. She has a dinner party. People show up, and there's nobody there, or nobody answers the door. The dog, in that case, it's not cited as a pet in need of aid. It's just the fact that the dog is barking. Again, further evidence that something is wrong. And the court says very clearly in Entwistle that it's the parents who are the primary concern, because if the parents aren't in trouble, then the infant isn't in trouble either. It's only if the parents are in trouble that the infant is in trouble. So they say, you know, the police were justified in being concerned for the parents, and if the parents were in trouble, then there was an infant involved, so they also had an emergency with the infant. So I don't think these facts can be distinguished from the facts here. The central premise of all these cases is you've got a situation in which the person stops doing the things that person routinely does, and there's no explanation for it. And in this case, you've got even more evidence of incapacitation because of the mail and the snow on the car and things like that. So I think when you put everything together, this case, based on both Entwistle and Townsend, is clearly on the side of a objective belief that this victim is in serious trouble, as of course he was.
Before you turn to the fingerprint issue, can I just get you to confirm that the gun charges, Commonwealth agrees that they should be reversed?
Yes, there's no way to...
And retried.
No way to get around the Guardado cases. I have two things to say in addition to what I've said in my brief about the fingerprint issue. One is the very context of this opinion, where he says, to the best of my knowledge, I've never gotten it wrong, is the prosecutor asked him, can you tell us what an erroneous identification is? And he says an erroneous identification is where the fingerprint examiner gets it wrong. He identifies a fingerprint to one person and it turns out to be another person. So that testimony in and of itself alerts the jury to the fact that there is such a thing as an erroneous fingerprint, an erroneous fingerprint analysis. So this is not an infallible science. But then he goes on to say, yes, it's never happened to me, to the best of my knowledge.
As far as he knows, right?
Yes, right.
But what is that statement worth when, for example, I could make the same statement?
Yes, right, of course. It's not worth much. And you know, if this court were to say prospectively, don't say things like that, we would have no objection to that. But there is, I mean, for the reasons, first of all, in a brief, that there was so much evidence of the defendant's guilt here, including the valid fingerprint evidence. But while I was reviewing this case in preparation for this argument, I realized that if you look at the defense as a whole, defense counsel at trial really does not challenge the fingerprint evidence. He cross-examines the expert very briefly. In fact, in his closing argument, he distinguishes the fact that the fingerprint expert testified that he has to go to an outside examiner to get his credentials renewed, but the ballistics officer doesn't. He does an internal review. And he says, you know, that shows you that how tenuous this ballistic evidence is. And that's what he dedicates most of his closing argument to, is the ballistic evidence. And the presumptive reason for that is because he knows, as the prosecutor argues, that if the gun in the attic is the murder weapon, the defendant is guilty. There's no way that some random gang member shot the victim and then put the gun in the attic. So he concentrates on the ballistic evidence and how subjective the ballistic evidence is. So he really leaves the fingerprint evidence alone.
Well, he tries to use it to his advantage, because
Right.
there was a third print
Yes.
that was found on the firearm that did not match the
Correct.
defendant's, and the Commonwealth's expert conceded that that could have been left by someone else.
Correct. Yeah, so there's no way in those facts that this could have had any harm to the defendant, let alone a substantial risk of a miscarriage of
Well,
justice.
nevertheless, you know, you've got the statement have you ever made an erroneous identification? To my knowledge, no. And then the expert further testified that no two individuals have ever been found to have the same fingerprints, right?
That's
Which
correct.
seems to be skating the line of what the Supreme Judicial Court has said don't do, and don't say that there's no possibility that two people couldn't have the same fingerprint, right? And so
The concern more is that saying that no two people have the same fingerprints, which, as far as I know, is still true. It's just a matter of probability of all the different.
is it really true that no two people have been ever found to have? I mean, there's been erroneous fingerprint
Right.
identification, right? And so maybe in that case, people have been erroneously found to have the same fingerprint.
Yeah, the problem is everyone agrees, I believe, that if you compare a fingerprint, an ink impression of a person's fingerprint, to a complete print that's someplace else, you will be able to determine categorically that it's the same print. The problem occurs when you have partial prints. And there's, as the cases discussed for decades, there's really no probability evidence of how much of the fingerprint you need to make a conclusive identification. So it's the problem with saying no two people have the same fingerprint is it implies that therefore any portion of a fingerprint will be able to be matched, which isn't the same thing. And that's the concern that the Supreme Judicial Court has had.
I mean, the general thrust is let's not use terms that suggest infallibility in this area,
Correct.
right? And both of these statements by the expert may not be reversible error, but they do seem to be kind of skirting the line of kind of
Skating the line, I think,
infallibility
is a perfect metaphor.
Okay.
Sailing too close to the wind.
Yes, I
perhaps.
believe someone once said that. If there are no further questions, the Commonwealth will otherwise rest on its brief.
No, thank you.
Hearing none, thank you very much. The
Thank
case
you very
is
much, Ron.
submitted. Extremely well argued by both sides. And if I could address Mr. Lynn for a moment. You've argued in front of me many, many, many times. You've won some, in fact, most. You've lost some. It has always been a pleasure. Thank you.
Thank you very much, Your Honor.
Our second case of the morning is 2023 P204. It is Commonwealth versus Camacho. And my apologies if I've mispronounced any names.
Good morning, Your Honors. I'm Karen Pickett. I represent the appellant Pedro Camacho. As Your Honors are aware, this is a relatively simple case, a very short trial, but we've raised three issues which I think affect the integrity of the verdict here. The three issues are essentially that the trial judge limited the ability of defense counsel to impeach and cross-examine the witnesses, that the Commonwealth improperly vouched for the witnesses by suggesting that their mere presence in court and talking to a room full of strangers about what happened should bolster their credibility. And I'll get into it, but the cases are clear that that's not allowed. And of course, the Commonwealth can rebut evidence of a motive to lie, but not with a witness's mere presence. And the third issue, if I have time to get to it, is the impanelment of one juror who we argue should have been struck for cause. And we also argue another juror that a peremptory strike was used on should have been dismissed for cause as well, which would have given Mr. Camacho an additional peremptory to knock off juror number 7, who ended up sitting on the jury. As you already know, there's a couple different factors in the trial judges limiting the defense counsel to explore certain issues. The first one is that on the cross-examination of the alleged victim's mother, the defense counsel was trying to establish that she was told in December of 2018 by her son, and then... oh, sorry.
Can I just interrupt you? How is that relevant? Because the mother, as I understand it, was the first complaint witness.
Right.
So the key, her testimony focused principally on when the alleged victim told her. And it's uncontested that it was in a 7-year time frame. And the issue you're focusing on is whether or not the victim number one, let's call him, told her in December or March or somewhere in between. And if anything, the fact that he may have told her sooner would seem to cut against your client. How does it matter that the mother may have been wrong in terms of remembering when he told her?
Yes, I understand what your point, and the Commonwealth also makes that point, Your Honor, but I'd say there's two responses to that. The first is, as a mother myself, if my child came to me and I believe credibly revealed a sexual assault that had occurred, I'd be down the police station within minutes. I think it goes to the credibility of, if your own mother doesn't go to the police right away, maybe there's some reason that she was not believing victim number one, especially given that he had been in trouble.
Where she was solely the first complaint witness, how is it relevant whether she believed the son or not?
Well, first of all, because she said that she went right away, which implies that she believed that it happened, and that goes to her credibility about what happened. If she's lying about when he told her, that's just a motive to lie, credibility issue, always relevant. The second, which I think is even more important, is that then the older brother testifies and says, oh yeah, then when he said it, I said, oh, that happened to me too. Well, the reality is that if they don't report it right away, the defense counsel can argue that they had 3 months then to come together and get their stories to corroborate each other, as opposed to going to the police station right away. And I agree. I mean, maybe the jury doesn't buy it, but this is really all the guy has, right? I mean, these are, all this case rises and falls on the credibility of the witnesses who testified. There's no corroboration, no physical evidence, no confession, and there was, of course, that lengthy time period.
Trial counsel sought to recall, I can't remember if it was victim one or victim two, but did not seek to recall the mother.
True.
Doesn't that undercut the claim that?
Well, I was thinking about that today, Your Honor, and one of the things that I realized is that he never really asked victim one about the time frame. And I believe that's because the judge, which I think is improper also, the judge, by looking at the police report, says, I don't think her testimony is inconsistent. And so she said, you can establish this through the testimony of the officer.
Which she did.
Which he did. And then also the Commonwealth says, well, the kid never said when it happened. And I looked again today, and on page 83 of volume 2 of the transcript, he said that he told his mother in 2019. So again, there's conflicting stories. And once the police officer established that there was that 3-month delay, meaning that he had reported in 2018, our position is that on the same day trial, this wasn't weeks later, that a victim one could be recalled to be impeached and asked again about the time, frame.
But why? But the witness has already been impeached. The premise of the argument seems to be that the only method of impeachment is to directly confront that witness with, someone else's testimony or whatever. The witness was impeached through another witness, so why would it be necessary to?
Well, I think, Your Honor, as
that
I
witness
just said,
directly?
he never really was. The victim number one was never impeached because he was never asked about the time frame, because the judge had said, get it in through the officer. And I would argue in a child sex case, when everything rises and falls on the credibility of the alleged victim, he should have been able to impeach him directly with the time frame issue.
But why? What difference does it make? The officer comes in and tells a different story. Okay, it was reported much later than the mother said it was reported. Okay, she's been impeached. Now it's up to the jury to decide who to believe. The job is done, isn't it?
She was impeached, but I'm saying the alleged victim, one, was allowed to testify. He told his mother in 2019. The defense counsel couldn't get into it with him because of the judge's ruling that he could only do it through the police officer. And once he establishes it through the police officer, then he should have been able to ask the, that's our position. I understand Your Honor's points about he was in effect impeached, but I think he could have, the judge should have allowed him to be directly impeached when everything rose and fell on the credibility of the two boys and their mother to some extent.
Can I just ask you a technical question?
Sure.
I'm looking at the transcript, and the mother was testifying, and she is asked on cross, your testimony today is you went to the police immediately after your son made his disclosure. And she says, I'm confused right now. I don't remember. And then there's an objection. Then there's a lengthy colloquy, the discussion of the police report, and all of this ends with the judge going back on the record and saying, objection sustained. What does it mean in this context for objections sustained without any motion to strike when the original objection was after she said, I'm confused?
I agree, Your Honor. It was confusing to me as well. I think what she was saying is that because the prosecutor showed her the police report and said, oh, defense counsel's trying to insinuate something that wasn't said in the police report, and then the judge looks at the police report and reads it a certain way, we read it a different way. And in fact, the trial DA says, I understand how they're reading it to say that they made an immediate disclosure to the police. And so I think what the judge is saying at that point is, I don't see it in the police report. I don't see that you can impeach this witness based on what was said in the police report, which again is...
But she already answered the question, and there was no motion to strike.
Because she said she didn't know, right?
So is that answer in or not? Is the objection sustained mean move on to a different topic, or?
I believe that was the impression that everyone had, and I agree. I wish I could tell you what exactly it meant. I think it was interpreted to mean because this police report doesn't say what you think it says, defense counsel, let's move on. And then you're clearly welcome to get into it when the responding officer testifies.
But clearly, the effect of the ruling was to shut off defense counsel from pursuing this perceived inconsistency, right? That's your...
That's right.
Basis of your thing.
That's the
there
basis
was
of
this
my claim.
Problem,
Both,
this apparent discrepancy between the police report and the mother's testimony, and there was more questions going to be asked, and the judge said, no, move on.
Right, exactly. And then the other, so my big problem really is I don't think a judge should be able to look at something that's not an exhibit or an evidence and then decide, because we don't know. Maybe the defense counsel had conversations with the police officer where he said this or that. It's really not the judge's, I guess, call to look at a police report in the middle of trial that's not in evidence and make a determination.
I think a judge had some latitude to govern the process of impeachment by documents, right? If there's no basis whatsoever in a document and someone's way of, that seems appropriate. But your point here is that it was at least ambiguous.
Yes.
And it turned out to be the defense counsel's position was
It would only be if the prosecutor had argued that the defense counsel had no good faith basis for trying to impeach her. And that clearly, if you read, now I'm telling you to read the police report, because now it's been submitted into evidence. But in any event, I don't think it's proper for a judge to look at a police report and then limit cross-examination based on that. I'd like to get into the issue of the Commonwealth's, I guess it's the opening and closing, although my focus really is on the closing. So what happened is in the opening, the Commonwealth made completely appropriate argument saying, use your common sense, you'll hear the evidence. And then then she said something like, and then think about whether there's a motive to lie or there's no motive to lie. And I'm sorry, I don't have the exact language, but I could get it for you. The defense counsel didn't object. And later on in the proceedings, actually when this issue was going on about the mother's testimony about the timing, the judge chastised, I guess, a bit the prosecutor by saying, I don't think you can say that. I don't think you can talk about motive to lie. And so that, that was fine, that went on. Then, of course, the defense counsel closing argument, as the Commonwealth points out, and all he was left with is, they're lying. I mean, there's really nothing else to argue, right? Because they came in and testified. Again, there's no corroboration, there's no confession. So it's either you believe them or you don't. And that's his right, right? And to say that these guys are lying. And that's, you know, the basis for arguing to the jury that he should be acquitted. And there were certain factors, the length of time and other things that could lead a juror to think that maybe the boys weren't telling the truth. And so then the Commonwealth gets up in closing, and actually, I think I'm going to read it because it's a problem, I think. It's back on page 141, I think, of the 140 and 141. The prosecutor argues, they don't have a motive here. Victim number 2A wasn't grounded. You didn't hear anything about that, and yet he took the stand. So I would argue it's proper for her to say he wasn't grounded, so he didn't have a motive to lie.
Saying it was proper?
I think it would be proper, actually,
Okay.
or if nothing, you know, it would be hard to argue to be overturned on that. I think it is a problem when she says, he took the stand, as if there's some sort of magical evidence related to that. He told a room full of strangers about what the defendant did to him as a child, and you're able to evaluate people's demeanor when they're testifying. Again, you're not allowed to argue that somebody coming in and testifying, perhaps pursuant to a subpoena, is evidence. It's not. Then she goes on to say, she says it again. You're able to evaluate how comfortable both boys were with talking to a room full of strangers about their penis, but they stood there and they told you what happened. And I can't think of a more classic, inappropriate vouching for witness argument by a prosecutor. I think on appeal the Commonwealth concedes that, but they say
the prosecutor would have been able to sort of say, you saw them testify.
Exactly.
You could assess their credibility, right? And
Right.
the prosecutor also could have pointed to evidence in the record that responded to the
Exactly.
claim of lying. But you're saying just that it was improper for the prosecutor to say, merely from the fact that they were testifying.
Exactly. That's exactly my point. So, and that's my issue with the judge's curative instruction. And I was thinking about this because, of course, I'm always confused about standards, what standard to apply. So we know that the judge called out the prosecutor. The defense counsel argued that it was inappropriate. The judge gave her own curative instruction. He didn't object to that curative instruction. So I'm not sure whether, because he objected to the closing, whether we review for prejudice and see if the judge's curative instruction corrected that prejudice, or whether it's under a substantial risk. I would argue either way, and I know the judge was trying to do the right thing, but the way she phrased it, she was basically saying, the Commonwealth can argue that them coming in here and talking to a room full of strangers about their penis can be used as a rebuttal. And that's not evidence. So I believe that the jury could have been confused by that, and it didn't cure the improper argument. I see that I've gone over, and I apologize, Your Honor, but...
No apology needed. We are done with questions on the third issue. I'm afraid you'll have to submit on the brief.
I will.
We will now hear from the Commonwealth.
Thank you very much, Your Honors.
Good morning. May it please the Court, Emily Mello on behalf of the Commonwealth. I'll begin with the issue that defense counsel left off on as far as the opening statements and the closing argument. So the correct standard here can be found in Commonwealth v. Bowdry, which is 445 Mass. It's actually at 587 here. This is where the objection to the closing argument was followed by particularized instructions, and defense counsel acquiesced in the curative instruction and specifically indicated that he was satisfied. The appellate court reviews for whether any error created a substantial risk of a miscarriage of justice. So here, the correct standard is substantial risk of a miscarriage of justice.
I'm sorry, which case was that?
That is Commonwealth v. Boudry. It is Beaudry. It is cited in my brief. It's 445 Mass at 587. Essentially, if there is an issue with a closing argument and there is an objection and a curative instruction is given and defense counsel acquiesces in that curative instruction and says that he is satisfied, which he did. At the conclusion of the charge, defense counsel stated he had no issues with the jury instructions. So in this particular instance, review would be for a substantial risk of a miscarriage of justice. And I would say that although the Commonwealth cannot say, look at the witnesses, they took the stand, and you should basically believe them because they took the stand. That is not allowed. Completely agree, and we conceded that in our brief.
Can I just ask you about the specific quote, "They told you what happened"? Doesn't that cross the vouching line? Because they told you what happened seems to imply that I know what they're telling you is true.
No, so I would disagree with that. Here is the passage that I think is at issue here. The prosecutor says they don't have a motive. I've called the victims AM and SM. SM is the younger victim, 10 or 11 years old at the time of the incident. AM is the older victim, between 12 and 13, or 13 and 14, I believe, at the time of the incident. They don't have a motive here. AM wasn't grounded. You didn't hear anything about that. Fine. Yet he took the stand. He told a room full of strangers about what the defendant did to him as a child. Not fine. Can't say that he took the stand and told a room full of strangers. That is not, that's kind of over the line. And you're able to evaluate people's demeanor when they're testifying. Totally fine. You're able to evaluate how comfortable both SM and AM were with talking to a room full of strangers about their penis, but they stood there and told you what happened. I think that is okay. I think that the crux of what she's saying here, the prosecutor, is saying, look at their demeanor when they're telling you what happened. You have to look at the whole sentence. But even assuming that it was impermissible, the judge gives a very pointed instruction about this, a curative instruction, after the closing argument. And you can see the whole instruction at transcript 2, 146 to 147, but I think that the important part is, or really the pointed part that gets to the issue here, the judge instructs the jury, you can't consider the fact that any complaining witness came in here and told a room full of strangers anything about what they testified. You can't take that as a fact that they would have no motive to lie.
You may well be right about the effect of the curative instruction at the end and the fact that the defense counsel seemed to think it was fine. The one wrinkle in this case is that this issue also came up in the prosecutor's opening statement. Right?
I would disagree with that
really?
completely.
Well, the trial judge certainly seemed to think
I was really not sure what she was getting at there, and I think that she misinterpreted what the prosecutor said. Here's what the prosecutor said in opening, and I know that my sister counsel here sort of paraphrased, but she doesn't say anything about lying. She does not say lie. She says, and this is on transcript 2, page 48, "Now you've all come here with two things that have actually prepared you for today's jury service. That's your common sense and your life experience. When you're listening to the evidence today, I ask that you use your common sense, you use your life experience. Think about when someone's testifying, does this make sense? Is there any motive for someone to be saying something?" I don't think that she's arguing that they have no motive to lie. I don't think it is appropriate in your opening, and there are cases that have said this. It's appropriate in your closing to argue why the witnesses do not have a motive to lie, especially if it is in response to the defendant's argument. And the defendant in his closing said lie more than 40 times. So I think that there was 100% a basis for that. In your opening, you cannot argue at all. But what she's not arguing here, she's saying, you've come here in your jury service, you have your life experience, you have your common sense. I would ask you to evaluate the evidence and motives looking at those things. She's not saying, look at my witnesses, they have no motive. She's saying, look at the evidence and use your experience to evaluate
I
motives.
totally take your point. My only observation is that there was this kind of prophylactic effort by the trial judge to sort of say,
I think the judge was
you
wrong.
can't talk about whether someone doesn't have a motive to lie, right? So the judge kind of puts the prosecutor on notice, and then you get to the closing argument.
Well,
the same issue comes up again. That's my only.
Sure, but I would just, and, you know, judges have a million different things going on, and they can't remember all the things all the time, but I would have to say that in this instance, and I don't say this a lot, I'm not really sure what the judge was getting at about the opening statement, because she doesn't argue that her witnesses don't have a motive to lie, and the judge is also incorrect because you can argue in your closing that your witnesses don't have a motive to lie. So I understand that the judge flagged it. I think the judge was incorrect.
It's based on evidence, right?
Right, but she does argue based on the evidence. I mean,
At the closing?
in her closing, absolutely. And I'm not saying, yes, saying that they got up and took the stand and that's a reason to believe them. No one is saying that that is allowed. But there was a curative instruction, appointed curative instruction, that the defense acquiesced in and said he was fine with those instructions. That curative instruction puts us back on even ground. The jury was specifically told to disregard the improper statement. All the other statements that she makes, arguing why they don't have a motive to lie, are completely proper and absolutely in response to the defense's entire argument, which is that everyone is lying. Mom is lying, older brother is lying, and younger brother is lying.
Let me just go back to the opening for a second, because you make a very valiant defense of it. But my concern isn't so much with whether it was vouching or argumentative or that sort of thing. It just struck me as it didn't belong in an
Why?
opening at all. Because your opening statement, you're supposed to just be telling the jury what you expect the evidence is going to show. Why are you getting it? Why would the prosecutor get into motive at that point? That struck me as beyond the scope of an opening.
I disagree respectfully and completely, because I think in your opening statement, no, you are not allowed to make an argument, but she isn't making an argument, but you are allowed to tell the jury what to expect. And sure, a lot of people get up and they say, this is who you're going to hear from, this is what's going to happen, and that's entirely appropriate. But you don't have to do your opening in that manner. And I think that you can say, this is your introduction to the jury. You're saying to the jury, you're going to hear from these people, and when you do, I want you to evaluate what you're hearing. I want you to think about that. Why is that not appropriate in an opening? You're setting the scene for your trial.
Counsel, unless my colleagues have further questions on this, I'd like you to move to the first issue.
Sure, absolutely. With respect to the first issue, I would say, of course, the judge has the discretion to limit cross-examination and to limit...
Can we start with how to read the transcript? Because the witness said, I'm confused, I don't remember. Objection, lengthy sidebar discussion, ending with objections sustained. How are we supposed to read that where there's no motion to strike?
So, sure, there's no motion to strike, and so I would say the testimony is not stricken in my reading of the transcript. My reading of the transcript is the defense attorney inquires of the mother whether she waited several weeks after her son's disclosure to report the assaults. The mother says, not weeks, I did it immediately. Defense attorney asks, you told the detective it may have been December 2018. She responds, I don't remember that then. Defense attorney asks, your testimony today is you went to the police immediately after your son made his disclosure. She responds, I'm confused right now, I don't remember. At that point, there is an objection. And there's this discussion at sidebar, and then the judge says, I'm going to sustain the objection only because I don't think that it seems consistent with her statements in the police report. I think she's getting confused, but you'll have an opportunity, of course, to ask the police. I take that to mean that she is sustaining any further line of questioning into when the disclosure happened. And I do think that that is appropriate. I think the police report could be read in a couple different ways, but I think
Why
that-
is it up to the judge to evaluate something that's not even in evidence and decide whether or not it's ambiguous and so forth? I mean,
It's not.
isn't
It's
that
not.
the
I don't agree with that. I think that it was appropriate for her to sustain the objection because the witness was getting confused and it wasn't going anywhere. And I think that we look at the trial judge and we have to understand that the trial judge is there evaluating the witnesses. And I've seen many of these trials, and I've seen many of these exchanges, and I'm sure that the trial judge has as well, and could see that we were kind of heading into just confusion land. She's saying, I don't remember, I'm confused, no, I went immediately, and so the point's been made. So she says...
Has it been made? I mean, she's
Sure, of
confused. She's
course.
confused because she's confronted with a discrepancy, right? And it seems like that's important for the defense to be able to sort of develop.
Well-
This is a key witness, and you want to sort of figure out, it may not be the most important discrepancy in the world, but it's material, and you want to sort of ask. And just for the witness to say, well, I'm confused, and the judge say, okay, that's enough, you've suffered enough. It doesn't seem quite fair.
Sure, and I think that that's one way to look at it. I don't think it was an abuse of discretion for her to cut off the line of questioning at this point. I would say that, one, the point has been made. Sure, it could have been made more aggressively and further, but I would completely disagree that the point is material. It is completely immaterial when the mother went to the police. She is the first complaint witness. There's undisputed that the victims waited 7 years to make their disclosure. Whether they made it in December of 2018 and mom immediately went to the police, or whether they made it in February of 2019 or whatever it may be, and then mom went to the police, that has nothing to do with their credibility.
To paraphrase what you're saying, tell me if I'm wrong, you're saying whether the mother believed them or not is irrelevant.
Completely irrelevant. One witness's, analysis of someone else's truth is completely irrelevant. You cannot ask a witness to comment on another witness's credibility. Not only that, just because another mother would have gone immediately, the question isn't, is this mom a bad mom? The question is, were these boys sexually assaulted? When mom went to the police does not matter. And the fact that the judge stopped this line of questioning after she already made the point that there was an inconsistency, and then again made the point that there was an inconsistency when the police officer testified, this is so far out of the realm of what is material here.
I don't know. You have a first complaint witness, and it seems relevant to know to what extent she understood the complaint she was hearing, and that's reflected in the degree of urgency with which she responds to it, right? I mean, her credibility is about what did she hear and when, and I think her immediate response, is this something I need to go to the police with, or can I sit on it for a couple months? That does seem relevant. It may not be central, but it seems relevant. And to say it's completely off the charts, not material to the case, seems
I would really vehemently disagree with that in a sexual assault case. The relevance of the first complaint witness is that disclosure and comparison of that disclosure to what the victims say and the victim's recounting of that disclosure. In fact, the Commonwealth could not even have brought in its own evidence that mom went to the police at all. That's how irrelevant it is. If the defense wants to bring it up and bring up when mom went to the police, then that's great. They can put that in. That is their right. And that she was impeached, and then she was impeached again when the police officer said, no, she came weeks later. There was nothing else to gain.
The timing of when the first complaint happened, isn't that pertinent to the introduction of first?
But the time, sure, yes. But the timing of whether there was a gap between when the first complaint happened and when mom went to the police, that is completely irrelevant. The timing of the first complaint, yes, relevant. And the timing of the first complaint is 7 years after the attack. That is the relevant piece. What mom does with that information is not relevant.
So you're saying that whether it was 7 months or 7 months in 7 years or 7 years and 4 months isn't relevant because it's the same general time period, is that right?
Sort of, and sorry, I know I'm going over my time. I think this is a really important point, and I want to make sure that we are understanding each other. I'm saying when you have a first complaint, the relevance of that first complaint is the timing of the attack versus the timing of the first complaint. So they waited 7 years to disclose. It's not relevant what mom does with that information.
I'm good.
Okay, thank you. Just one technical point.
Sure.
You filed a housekeeping-type motion
Yes.
on the appendix. I don't remember if you, in your motion, you note whether or not there was any objection to that or not.
I did file it on council. I don't know if she has an objection.
Okay, so I meant frankly to ask, but it's too late for that. If the defendant has any objection to the housekeeping motion, you have until close of business tomorrow to file such an objection. With that, the case is submitted. Thank you both very much. Again,
Thank you.
very well argued by both sides.
I emailed you. I don't know if you saw it. Okay, great. Yeah, it was just.
Our third case, and the last before we take a brief mid-morning recess, is 2023 P278, Commonwealth versus FREITAS.
Good
I
morning.
have the pleasure of hearing from the Commonwealth first.
Good morning. May it please the court. Alicia Sanchez on behalf of the Commonwealth. This is the Commonwealth's appeal. The judge erred in allowing the defendant's motion to vacate his guilty plea, and he erred in allowing that without first holding an evidentiary hearing. I'd like to address the issues as they're laid out in my brief. That's whether there was newly discovered evidence, whether the report support a claim of egregious government misconduct, and whether there was ineffective assistance of counsel. So in the defendant's motion, he characterized the two test reports as newly discovered evidence. They were not. These reports were reasonably discoverable by the plea counsel, and the report themselves reference the fact that the refusal was given due to the interferent detection. Whether there was, the motion counsel also argued that the test report supported a claim of egregious government misconduct. He alleged that the Commonwealth, through the officer, materially misrepresented why the results were unusable, and claimed that the officer's report implied that they were unusable because of the defendant being at fault for some reason for not blowing enough air. But this was in no way, I apologize for this mic issue. This was in no way a misrepresentation, let alone a blatant one. The statement that the defendant could not blow the required sample to perform the test is accurate, and that's because the required sample is one that's free of a deterrent.
Well, we know what it means not to be able to blow the required sample. It means that either the individual's not cooperating or too inebriated to perform it. It doesn't mean that you've got this interfering substance in your breath and therefore there is an interferent, right? I mean, this is, I'm kind of surprised that you were saying there's no at least misleading statement here, because the report really establishes the reason why there is an interference here is because of the way that the defendant was blowing into the test, and that wasn't true. The defendant was blowing just fine. So the phrase therefore really establishes the causation here that's being drawn out, and that wasn't true.
So the phrase, just to read from the police report, it says, JARRAD was offered the test multiple times. However, he could not blow the required sample to perform the test. Therefore, he was given a refusal on the breath test due to interferent detection. So the way I read it is, he could not blow the required sample that was free of interference. Therefore, he was given a refusal, and then plainly stated.
Say there was an interferent detected. Why? I just don't understand why it was written that way.
So, I
mean, you see my point, right? It really suggests that the defendant is doing something wrong here, and not that maybe there is some diabetes or some condition that prevents.
So if I can rephrase that in terms of, even if you can read the language to support your reading of it, that's not the thrust of the language. The thrust of the language is he's not blowing enough.
See, I respectfully disagree. I read this sentence, and in no way do I come away with the idea that he did not blow enough air.
Assume hypothetically we don't agree with that.
Okay. Okay. Well, even to say that, assuming this did suggest something that it was due to blowing air, the plea counsel is able to. It states right here, interference detection, and plea counsel has access to the CMR, and there's 501 CMR section 216, which states that where an arrestee fails to provide the required sample, a police officer is to note that test as a refusal. So to me, this statement here is not any misrepresentation, let alone a material one that would suggest that the officer is.
Refresh my own recollection, because it's been a while since I read this case. Was the police report already turned over in discovery to the defendant?
It's my understanding that it was filed with the district court, and the plea counsel had this report.
Had access to it, or had the actual report?
It's my understanding, I can't at this moment say whether he had it or not, but I would say he at least had access to it. I'd have to reread the motion of the motion counsel, but it's my understanding that he had this report. But we don't know exactly the details of what happened from plea counsel's perspective, because, as I would point to later on in my argument, there's no affidavit from plea counsel supporting the defendant's claims.
So the mass regs that you referred to require the officer to record this interferent detection as a refusal, right?
Yes.
What was the citation on that mass reg? Do you have that in front of you?
Yes, so it's 501 CMR section 2.16.
Could you explain why that's considered a refusal? I'm having a hard time getting that.
Unfortunately, I can't provide a reason why the CMR requires that. My understanding is just when there's not the required sample, when it's not a required sample to perform the test, then it's just noted as a refusal.
But isn't there a difference when the party is not blowing enough air into it versus there's something in their system that is interfering with the test?
Yeah. So I think in a situation like that, in this case, there was an interference detected, so on the breath test, it would be message 8, interference detected. And so in this report, it says that the report, that there was a refusal due to interference detection. There's also another option, which is code 17, minimum volume not achieved. So you might expect in the police report to read, if he was given a refusal due to minimum volume not achieved. But here, those words aren't in the report. Instead, it's interference detected.
And so what are we supposed to interpret? Are people so because you don't have that language that's what was really going on, and that the refusal was this non-refusal, was this? Right, a common situation, right, is people with diabetes have a high level of acetone in their breath, right, so you can't get a valid test.
Yeah.
Do all those people get marked as refusal, under your understanding?
It's my understanding that under the CMR, if it's not a sample that is, if it's not the required sample to perform the test, then it's noted as a refusal.
Okay.
Well, refusal has a couple of implications, right? I mean, one, the big one is it's not admissible at trial, right? And then the second one would be license loss, right? If it's actually a refusal. So in other words, the regs, by referencing refusal, that's not just a word that's taken out of thin air, that it does have some implications, right?
I think if the way that this, placing all the words together in that sentence, because you can't splice it apart, taking that all together, it's my reading, and could have been plea counsel's reading, we don't know, that it's due to, as it's stated, due to interference detection. And so plea counsel could have obtained the reports, seen that it was interference detection, and that it didn't have, that there was enough air blown. But even then, having those reports, the question is whether it would have been ineffective to have not advised the defendant about these alleged issues, or, but really, the question is whether, if he had had these reports in hand, whether there's a reasonable probability that he would have not pled and insisted on going to trial. And here, I think the issue is, the focus should be, he would not have done so because he had overwhelming evidence against him, and whatever he could, arguments he could claim about possibly being able to impeach the officer on this information, or that evidentiary value of the reports is negligible and does nothing to alter the strength of the Commonwealth case. And here we have, he caused an accident, he was injured, his head was injured, he injured somebody else, he had slurred speech, he had red glassy eyes, he failed 3 sobriety tests, he had the smell of alcohol on his breath, and he admitted to drinking 2 Captain Morgans with Coca-Cola an hour before the accident. So based on all of that, I don't think that, it would have been rational for the defendant to go forward with these reports in hand, insisting on going to trial.
So in terms of the evidentiary hearing you've requested by way of alternative relief, presumably all this could be explored.
Yes.
But could you focus on the scope of that hearing? For example, do you envision that hearing going into whether or not the defendant had access to the police report, the extent to which Commonwealth actors may have misled? What's the scope of the hearing?
Definitely. I think the scope would be anything that's beyond what's in the police report, which we could ask the questions, we could ask plea counsel exactly what he had in hand and whether he was just listening. He advised the defendant that he wanted to obtain these reports, but that he decided not to, but he eventually decided not to if the defendant wanted to plea within 2 months of the arraignment, which he did. We could ask the police officer what he meant in writing his police report and his citation to the CMR. We could get clarity on that. We could cross-examine the defendant. So it would be a broad scope of exactly what happened, because here all we have is the police report and the defendant's self-serving affidavit. And
You didn't ask for an evidentiary hearing below, right?
So
You went to the hearing, the judge ruled against you, and now you come up and appeal and said, well, we really should have had an evidentiary hearing. But you didn't ask for one when you had the opportunity.
So I don't think we need to ask for so what happened was there was the Zoom hearing. We objected. We never waived our evidentiary hearing. And I cite to the case Gordon, it's an appeals court case, where I discussed that issue at the end on page 31 of my brief. But I think I cite to Sylvain 2, where the Commonwealth waived, a contrast Sylvain 2, where Commonwealth waived the right to cross-examination. The trial judge relied on affidavits of the defendant and plea counsel who are absent. But I think, and I quote Gordon, that says, the motion judge took the unusual step of granting what was effectively a motion for new trial without holding an evidentiary hearing. And it's my understanding of Rule 30C3 that if there's no substantial issue, a judge can deny the motion without the hearing.
Well, how would the judge know there was a substantial? You didn't say, well, the judge, there's a substantial issue here. You just said you just objected.
So
How was the judge supposed to know he had to do an evidentiary hearing?
I think in order to have allowed it, the judge must have been, we don't know because
You're saying it's a one-way ratchet.
yes, because the judge allowed, there's just a marginal endorsement, and we don't know exactly, I had inferred that he thought that, I had inferred that he had assumed there was a substantial issue, and therefore he allowed that motion for new trial. We never got the opportunity to present evidence, to question witnesses, and as the case Gordon says, the ability to allow a motion for new trial is more circumscribed than the ability to deny it. And so we would ask first that the court reverse the order, but if you should find that there's a substantial issue, that it be remanded so that we could have an evidentiary hearing.
Can I ask just one more question?
Sure.
Is it your understanding then that any time, playing off Judge Hodgens' question,
Yes.
anytime someone gets an interferent detected result, that they lose their license, it's deemed a refusal?
So here the defendant has
I'm
45.
just saying, you say every time there's an interferent detected, it's a refusal. Every time there's a refusal, you lose your license. So is that the case?
No, I'm sorry. No, I don't believe that. I think there's a difference between when you refuse, there's an automatic certain number of days of, when you refuse to participate in the test, there's an automatic terminate, or my words are lost at the moment, revocation of the license. But when there's interference detected, that's different because it's not, it may be at the fault of the defendant, it may not be, but that does not kick in the automatic revocation.
You said it's deemed a refusal,
Yes,
but not the refusal that carries the consequences of revocation.
yes, they're two different things. They're two different things. All right, thank
Counsel,
you.
thank you very much. We'll
Thank you.
hear from the defendant.
It pleases the court, Scott Martin for Mr. Freitas. Good morning, Justices. With all due respect to my sister, I'll get right to the point. The CMRs are very clear, and I argue this issue all the time. 501 CMR 2.16 governs the refusal process for a breath test. And what it states is, after a person is advised of the rights and consequences of submitting to a breath test, if they refuse to participate or decline to cooperate, no test shall be given. It also states if at any point they refuse or fail to supply the required sample, it is deemed a refusal. That is not what happened here. Error message 17, and this is the crux of my argument. The Commonwealth has never established here that Judge Julian, who gets great deference, as you know, pursuant to the case law cited, I believe it's Sylvain and upheld by Liz, he was the...
Yeah, but great deference for what? Because there was no hearing, no evidentiary hearing, there were no findings, there was no affidavit of counsel, and there was no credibility determination based on the defendant's affidavit. So what are we deferring to?
Okay, he was the plea judge, and he obviously found nothing wrong with the argument now to grant a new trial or anything that happened at the plea hearing, the original plea hearing, that would give him great pause to discredit Mr. Freitas's affidavit. The case law is clear that he can decide the issue based on the affidavits, but he went beyond that here because we submitted far more than just affidavits. Not only did we submit the error message codes that apply to the test, and number 17 is minimum volume not achieved, he did supply the error. We also submitted the breath ticket that showed that for test 1, he submitted 2.1 liters at 13.3 seconds. For test 2, he provided 2.6 liters at 9.6 seconds. We provided the breath test manual that shows...
Okay,
let
me just stop. Did plea counsel have the police report or only access to the police report?
I think it's safe to assume that the plea counsel had a police report because he had pled him out 2 months after my client was arrested and he was privately retained. It would only make sense.
Isn't the interferent issue is hiding in plain sight in the police report? It's right there.
Curtailed, and this is why I state Judge Julian did not abuse his discretion, because I believe he considered a totality of the circumstances.
Do we have any idea what Judge Julian considered, since he didn't really say?
Well, he said enough in his decision that he considered all submissions, which included the breath test reports, and he mentions that in his decision. He said all submissions, a review of the facts, and the breath test results, and it would be the proverbial, maybe not rounding the bases twice, as Your Honor mentioned earlier. There was no need to go any further. And furthermore...
Except if the interferent issue is right there in the police report, even if the statement in the police report is somewhat nonsensical, at least to some of us, there's lots of evidence that your client was intoxicated. Your client pled to a very favorable resolution.
I disagree with that being favorable, because for an OUI, when you take a quaff, a continuous out of finding, you're subjected to a second offense if you pick up another one. So you don't get a true dismissal. Number one. Number two, the facts here were actually favorable to the defendant. And if I could briefly go backwards, the fact that plea counsel, I did not get an affidavit from plea counsel, it is clear there's no need for an affidavit from him, because it's clear he didn't understand the issue for two reasons. Number one, he never appealed the breath test suspension that Mr. Freitas didn't actually refuse the test. One, and number two, 501 CMR 2.13 and Commonwealth v. Ralph Pierre, Commonwealth v. Frazier, all state that the officer has to watch the defendant as a primary focus for 15 minutes prior to the administration of the test. There's nothing in the report that indicates Mr. Freitas burped, hiccuped, regurgitated, coughed, or introduced any interferent while he was the primary focus. If he had, and that's what caused the interference from Mr. Freitas, he would have been obligated to start a new testing sequence pursuant to 501 CMR 2.14 in an effort to get the two tests in a row within 0.02 of each other.
You seem to be putting thoughts into the mind of plea counsel. Isn't it entirely possible that plea counsel sat down with the client and said, here's the deal. If we go to trial, this is what you're facing. If we accept this 24D resolution, you're going to lose your license for this period. You're going to have these other consequences.
It's not. Because on a first offense, he would get the same punishment after trial almost 99% of the time or more that he would if he took a quaff, except it would be a quaff versus a guilty. That would be the only difference, because it was a first offense OUI. And secondly, when we look at the review of the facts...
Wait a minute, but on a plea, though, tell me how, before he got the 24D in a quaff, how could he have done better than that on a plea?
On a plea, you can't. But on a conviction, you get the same punishment, except your record would say guilty versus quaff dismissal.
If this guy, he pleads 2 months after he's charged, if he wants to get on with his life and put it behind him, have the program, and then it's dismissed, why would he want to drag it out for another year and go to trial and endure the,
I can tell you exactly why. Because the facts in this case are weak. My estimation, I try OUIs 40 or 50 a year. If you don't try this OUI, given the bungling with the breath test evidence, you wouldn't try any of them. He's listed as was talking rational and was coherent. The Commonwealth mentions bloodshot, glassy eyes, but he had just been hit in the face with an airbag, which has a gaseous powder that causes your eyes to be red. He has some unbalance, but he's also answering questions. I had 2 Captain Morgans an hour ago. There is no slurred speech mentioned in this report, and I take issue with that because it's also listed in the Commonwealth's motion. He's described as talking rational and coherent.
But there was an eyewitness who said he sailed through a stop sign, crashed into him, and then he hit a house.
Negligent operation. So if we go to a fact finder, just please hear me out. If we go to a fact finder and say, here's a person who offered his blood alcohol content to the police, and the same police officer that determined he was under the influence of alcohol said that he refused the test because there was an interference, and then you question them about, well, you watched him, he's a primary focus, there's rules, regulations, you're trained. Your manual states he blew on 2 occasions way over far over the 4.5 seconds and 1.5 liters of breath. He was 2.1 liters on one, 2.3 on the other, 9.4 seconds and 13.3 seconds. It's almost triple the amount of time, double to triple, and he's way over the amount of volume to provide a sample. But for that bungling, they could have brought him to another police station. They could have started a new testing sequence. They could have reevaluated him for 15 minutes. A fact finder says he offered, any notion that he was not cooperative is cured by the fact that they state he's offered it several times, and never once does he say, I won't take it. He's trying this test multiple times to give a blood alcohol content, and but for the officer stating, I'm refusing him because there's an interference, Mr. Freitas did nothing to offer an interference in this case. We see it all the time. A person will cough. They won't blow hard enough. These are the things people do to get around the test. Mr. Freitas is blowing in the test repeatedly, and he gives one valid sample that can't be used against him because you need two.
Well, that's just it. But even if everything you said is true,
Right.
none of it's admissible.
I respectfully disagree that if a person is offering the test and the officer puts it out there that he refused, that bears on the officer's credibility.
But wait a minute. But that's not coming in at trial. A jury or a fact finder is never going to hear any of this BT evidence.
I believe it would come in. We can respectfully disagree because the results would not come in for two reasons. Number one, it was out at that time period. And number two, because there's only one valid test and you need two. But the fact that the officer said he refused and that he was offering it, and we can show that the officer bungled the evidence in this case, shows a fact finder that he was trying to submit his blood alcohol content, and but for the bungling of that evidence with the officer, that has to provide reasonable doubt to a fact finder that here's a man who wants to give his alcohol content, and the officer stopped the testing process under the false guise that he refused.
How much time was there between the the crash, and the what you call the bungled test?
It was, I believe it was a little over 3 hours, which the Commonwealth references in their brief.
Doesn't that undercut your argument that
No,
the
it's
jury's
actually,
going to find that so
our position is, and I anticipated, Justice Milkey, this question. This is, well, no, because it comes up in reverse on the other end, because I've had OUIs, and the Commonwealth commonly will do what's called a retrograde extrapolation, and they can take it from 3 or 4 hours and go backwards. There's a certain number and tell you what you would have been at the time, because the average person loses about 0.02 per hour. That would be for one beer, a glass of wine, a shot of hard liquor. So they can go backwards and do a retrograde extrapolation, which they don't mention in their brief. But that's something that Mr. Freitas could have done had we had the proper testing. So.
But what do you say to the regulation? This is 501 CMR 2.13. Neither the statute, the BT statute, nor regulations create any obligation to administer the BT.
Right, and I agree with that. They also do not have to choose breath or blood. However, they did choose to administer a breath test here, and the breath test operator erred in determining that Mr. Freitas refused the test. He didn't. There's no refusal for an interferent. When there's an interferent, what happens is they start the 15-minute observation time over. For example, if a person were to cough 8 minutes into the observation, they would start the 15 minutes over, let it dissipate, and then they would start the testing sequence pursuant to 501 CMR 2.14, which would require 2 tests in a row within 0.02 of each other. That's how that goes. There's no refusal unless a person fails to provide the adequate breath sample, because then the argument becomes you can't just keep giving them the test in perpetuity. If they fail to provide for a minimum level not achieved, you stop the test and it's deemed a refusal.
What about the Commonwealth's argument that I recall the defendant referenced in his affidavit that he had blood taken at the hospital? Is it a fair inference that if that blood evidence really showed he had a low blood alcohol or no blood alcohol content, that he would have just gone to trial with that?
Well, that would be a legal burden shifting pursuant to Brady. The defendant has no obligation.
Yeah, but we're talking about a motion to withdraw or a plea, though. I mean, doesn't that somehow play into, this is evidence he's offering in his motion to withdraw the plea. I mean, can't the judge evaluate that?
The evidence he's offering to withdraw the plea has nothing to do with his blood test, which would not come in pursuant to...
It's in his affidavit, though.
Right, pursuant to Commonwealth versus Moreau, and it's in our brief and in our argument and in our motion, that the test wouldn't come in. And the Commonwealth is under a misguided notion that because they don't test the actual blood, that it would come in, which ignores the fact that pursuant to Moreau, and now on April 1st, Commonwealth versus Aquino, the SJC just heard that, and Commonwealth versus, I believe it was Puricelli, stated that it's the test or the analysis, and they distinguish it from the blood draw, even if it's a third party. So that test was never coming in. This issue was going to be whether or not he refused the breath test, and whether or not the officer erred in making that determination, and would that bear on his credibility at a trial, which it would have. And if plea counsel had investigated that, which he has an obligation to do, and I'm running low on time, so I'd like to get that argument out. There's a Strickland test. If his performance was deficient.
Yeah, can I just
Yeah,
comment on that
sure.
while you're
It's in my
looking?
brief anyway. So,
Yeah.
right.
It appears that a lot of the arguments you're making today are more ineffective assistance by plea counsel than affirmative misbehavior by the Commonwealth.
No, it's a totality of the situation, and that's what I believe Judge Julian made the decision on pursuant to Rule 30, that an injustice had occurred. It's not localized just to the statement in the police report. The statement in the police report, coupled with the fact that the lawyer, who may be a good lawyer, but did not understand this issue, which was evidenced by the fact that when we talk about getting on with your life, which is a great point, Justice Hodgens, he had 10 days to go to the registry and say, I didn't refuse anything. I submitted to that test. I don't know where an interferent came from. I provided the adequate level and such, and if his lawyer investigated that, he would have had a great issue for appeal to get his license back while he pursued his avenues of defense. Even if he was unsuccessful at the registry, which he wouldn't have been because it shows he blew it for enough time and enough volume, he could have appealed that to the district court and sought relief there immediately. It becomes a civil case, a certiorari to the district court, which I have done plenty of, and you can get your license back from a judge determining that it was error from the registry. So he had plenty of options. There was an OUI first defense. There were no aggravating factors which would trigger that blood to come in, and that's exactly what Zucchino and the other case that I referenced stated, that unless there's an aggravating factor, the blood does not come in unless the defendant consented to that. So that would not have strengthened the Commonwealth's case. So here we have an officer misrepresenting in the police report, which my client relied upon because his lawyer did not properly investigate to learn that he didn't refuse anything. And the facts, there's no strong odor. The eyes are explained with an airbag. He's not really unsteady on his feet unless he's performing tests, but he has a laceration and a bump on his head from a head trauma in an accident. And he's listed as talking normal and cooperative, and he's giving responsive answers. There's a lot of reasonable doubt there. If you couple that with the fact that he's trying to give a blood alcohol reading, and but for the officer making an incorrect, I won't say nefarious, but an incorrect determination that he's refusing it, if you're a fact finder, that's very strong evidence of reasonable doubt, at least, that he's not impaired, where he's trying to give that evidence and the officer prevented it through a mistake. It's just, I have nothing else to argue because that's...
Perfect timing.
Exactly. Well, except Judge Julian didn't abuse his discretion on making that determination either.
Thank you both very much. Very
Thank you.
interesting case, well argued, and
Appreciate it.
the case is submitted. We are going to take a very, relatively brief mid-morning recess. We'll be back in about 15 minutes' time.
All rise. Go stand in recess. Good to see you. Nice to see you. Going slow out there. How are you?
Nice to meet you. Good job.
You gotta watch out for this one. He does very fast.
I used
Court is reopened. Please be seated.
Thank you for your indulgence. We are back on the record with our fourth case of the day, 2023 P520. Indulge me on this, Joseph SZAWLOWSKI versus George Price and others.
Yes.
Seems I was in the ballpark.
Yes, you were, Your Honor, if it pleases the court. I'd like to start today by explaining to the court discussing the SLAP portion of this appeal. There's two portions.
Can I just stop? If we can start the clock, please.
There's two large portions. There's two large portions. One portion is SLAP, another portion is litigation privilege. They're two related but different topics, the court's well aware. In this case, the trial court, Judge Salinger, found that almost identical actions on the part of one group of defendants enacting an amendment to corporate documents was not petitioning. That group of documents purported to enact that change through an action without a meeting. The second group of defendants, the Saul Ewing defendants in this case, purported to enact the very same documents through a different method, through a special meeting. The trial court found that it was not petitioning to enact those documents through action without a meeting. Therefore, the Kasner and Edwards parties were not covered by the protection of the SLAP.
You're saying at a minimum there's an inconsistency in what?
No, Your Honor, not an inconsistency. Well, I suppose at one sense inconsistency, but that there is not solely petitioning involved in the Saul Ewing party's actions. Therefore, they're not entitled to the SLAP protection, especially under the new standard that we've come with, the Bristol asphalt standard. Many of these pleadings before the court were submitted prior to the Bristol asphalt case. That Bristol asphalt case does away with the Blanchard hospital decisions and returns to some extent to the Duracraft, but also highlights that it's got to be solely petitioning. The court cannot parse the documents and decide, well, could this be non-petitioning? If there's actions that are not solely petitioning, then you don't get the SLAP protection.
Let's assume for the moment that you're right with respect to the anti-SLAP statute with respect to the special shareholder meeting. Don't the Saul Ewing defendants have a strong argument for the application of litigation privilege in that case? Because perhaps unlike the Kasner and Edward defendants, the litigation was clearly underway or in a preliminary stage. Their alleged actions would seem to be responsive to the various objections and claims that you had made. So why wouldn't the litigation privilege at a very least cover the Saul Ewing defendants' actions?
I'll admit their claim to the litigation privilege is perhaps stronger than the Kasner parties, but I still believe that those actions of a special meeting are not litigation. The Kirker case, which specifically excludes business matters from the litigation privilege, states that business matters don't get covered by litigation privilege. It would be hard to find something that is more business matters than a special meeting amending corporate documents, and specifically...
Yeah, but you had raised in your lawsuit that the written consents adopting the 2018 amendment, they weren't valid because those actions weren't voted on at a shareholder meeting, right? And so the Saul Ewing defense say, okay, well, maybe you have a point there, so we're going to go ahead and sort of take the steps necessary to bless the written consents at this meeting. That seems to fall within the ambit of kind of conduct taken in response to litigation.
That was one of the claims as to the invalidity of the terms. The other is that they were in violation of the documents themselves and a breach of fiduciary duty of the parties. I can see that that is a closer call on that case. I think if anything were to be decided by this court, to decide that, yes, perhaps the SLAP doesn't apply, but if the litigation privilege did apply to Saul Ewing, I could possibly understand that. But I still think Kirker applies in that just because litigation has commenced, the Saul parties don't get to go and conduct business activities, which is not, it's a difference between defending the actions and enacting them. The litigation is defending the actions. The special meeting is enacting the changes. What they did is take actions to enact the corporate changes, not simply defend actions that had happened. Litigation is defending that. The corporate meeting is enacting a change, and that's the business matters exception to Kirker. And I think that's where that applies in this case, that the Saul Ewing parties don't get that coverage because they didn't simply say, Your Honor, we think these things apply because X, Y, and Z. We think this is valid because X, Y, and Z. They went out and said, well, we are going to go out and enact these changes to the corporate documents. And the Baker case, which is specifically deals with corporate counsel shouldn't be the ones going out to enact these changes to disadvantage a minority.
Can I ask you about that? So this goes maybe back to the Kastner defendants, but your Baker and Kirker are your key cases, right? And those cases involve attorneys representing companies, right? Is it your allegation here that at the very start, Kastner was representing the companies, or were they representing Frank and Chester?
I believe they were representing the companies. They were paid by the
From
companies.
the start, do you allege that? Because it's not totally
That's
clear.
not totally clear, and in my oral argument with the court, I had asked for leave to amend to make those allegations more clear. I believe there's a reasonable inference that there is an allegation that they were paid by the companies, not Chet and Frank. They took the company's corporate documents. They took over for the companies. And had
Eventually,
I
they're
been
representing the companies as against you, but I guess initially, it seems like you don't really have a Kirker or Baker
I think my
claim unless they're representing the companies and freezing out a minority
I think the
shareholder.
inference is there. I think I could have been clearer, and I did ask for leave to amend. While I had asked for leave to amend, Judge Salinger cut off that question by saying that we are here for an oral argument, not to amend. I later asked for an emergency motion to amend because in a related case, Judge Salinger made clear, no, despite the scheduling orders that we have in these cases, if somebody has a request to amend, you may make that. That was in a related case. After Judge Salinger said that, then I requested leave to amend.
Before I forget? As I understand it, the current case is embedded with a number of other related cases. Are there updates to those cases that this panel should be aware of?
There are some updates. I don't know that they necessarily matter. There was a claim against me personally for breach of fiduciary duty. I prevailed in that claim with a 0 judgment against me. There are several.
Summary judgment or?
No, after trial. There are several issues finding that I did breach my fiduciary duty in several respects, but without any damages, and there was 0 owed. Those I plan to appeal. The land court found that the home of my brother, it was adversely possessed. That was in a recent Lawyers Weekly case. I believe that may be the cover. So there have been some significant updates. With regard to the probate court, there's been no movement. With regard to the other underlying cases, there's been no movement. With respect to the and I'll say, I think we touched on it here, but with respect to the underlying actions of the amendment of these documents, both Judge Goodwin and Judge Salinger found that they were invalid. They violated the agreement. They were invalid. And that lines up with the Baker case.
So this gets back to the secondary holding of Judge Salinger in this case as to the Kastner defendants, that there are no damages, right? So I really want to know what your answer is to that. Like, if the amendments aren't valid, you don't have any.
So it's perplexing. In this case, Judge Salinger says, well, it's a catch-22 in reverse. Either the actions are valid, and therefore they're valid and you have no damages, or the actions are invalid, in which case you get your rights back, therefore you have no damages. Subsequently, Judge Salinger found in a related case, the actions are invalid, but because you didn't claim your rights in a specified way during your challenge to these actions and the applicability, you've therefore waived your rights. Therefore, you don't get the benefit of the original SSRA. Even though it is valid, you have to accept the rights under the invalid agreement because you waived your rights. And Judge Salinger speculated that, well, there could be no possible damages because either A or B. He then 4 months later decided, well, we have an option C, is that they are invalid, but you don't get your rights back. And I think in this case...
But is that necessarily inconsistent? Because, as I understand it, in the second ruling, he's saying you should have done something affirmative at a particular point in time, and you didn't do it. So you would have had rights under the original agreement if you had acted in time, but you didn't.
I think it's inconsistent in that I did demand my rights under the original agreement initially during the period. He's saying that the invalid option exercise, the exercise under the invalid agreement, triggered your rights under the original agreement. Therefore, you should have exercised rights under the original agreement that you didn't have under the amended agreement. And I don't think Judge Salinger is right in that point, but I think that highlights the fact that the trust is currently harmed. It's harmed not only that way, but the loss of certainty, the loss of diminution in value of the trust's shares. It's been 4 years. There's been no resolution whatsoever. I think the value of the shares, whether or not they have been sold, they have not been sold, but whether or not they have been sold, the value of them has been harmed.
But the valuation is decided pursuant to the provision that all the grandsons agree to, right? I mean, so I don't...
So Judge Salinger is saying I don't get that.
Okay. I mean, it's really hard, it's really hard to sort of process this issue by reference to other lawsuits. You are a plaintiff. You have an obligation to plausibly, allege all the elements of your claim. One of these damages. And I just look at your complaint. I don't quite understand what the plausibly alleged basis for damages is here.
And I think similarly in the Baker case, the plaintiffs prevailed in finding that the agreement and the actions were invalid. But the court still found that, no, you were also harmed, even though you've lost these rights, even though you've invalidated these changes, and the court found that they were invalid under the original agreements and whatever in Baker, you still had been damaged. And I think in this case, the amount of damage is difficult to explain, but the fact that there is damage, I think, is clear in that it's the loss of rights or the potential loss of rights or the uncertainty and the harm to the value. If I were a Tesla stock, you can go and see the value of that stock every day because it's publicly traded. If something happens bad, the value goes down. It doesn't necessarily mean that you've sold it, but you've been harmed by the value going down and that uncertainty.
Okay, but now assume, as a hypothetical, that we were to reverse and this goes back, but assume that you don't get the benefit of the original agreement. How do you prove damages? Is this just dueling experts on the stand saying what the share is worth? Or?
I think, yes. What would it be worth under the original agreement and what did you get for it? Furthermore...
Or what is it worth market value?
Or what is it worth market value now? Or potentially if I settle with the other, and there is no determination, there is no final judgment in the other that's a determination, there's some settlement, then there's also damages because what should you have gotten under that original agreement is the amount that I believe I'm entitled to, and whether it's joint liability also. So if there's more than one wrong, whether I get that money necessarily from the defendants in that case or the defendants in this case, I believe they're jointly liable, and I could get that from all.
Is this litigation, and by this I mean frankly everything, not just this case but the other cases, is this all about now what a fair price for the share is, or do you or your aligned party still have an interest in the operation of the farm enterprises?
I think there's some question about that. I would say that the purported exercise of the option for $4 million, I would not accept. I would much rather keep the shares than accept that. I would accept pursuant to the agreement that the original brothers had. If it were going to get repurchased for the fair market value of the assets, then that would be what the original brothers agreed to. That was the original agreement. That's what it provided. That's what the court has found should have been the valid valuation. Yes, I would be repurchased for that amount, but for any amount less than that, no, I would not be willing to be repurchased.
Well, my point, in case it wasn't clear, is to at least a great extent, at this point, this is about money.
To a great extent, yes.
Yeah, and there is presumably a dollar value that would make this go away and everyone would be happy, and you've identified today what you say is your dollar amount. We will do our job in resolving the legal issues you all have put in front of us, but
it is
frankly, there's a lot of litigation going on over a dollar amount that
it is
it's hard to understand why this is still a live controversy.
It's a large dollar amount and it's a large difference between the parties. And there's over 1,550 acres of land in this company. There's houses, there's apartment buildings, there's tractors, there's hundreds and hundreds of thousands of dollars for a single tractor. There's dozens of them. It's a huge number, and the amount is staggering, and the difference between the offered amount and the amended, the $4 million of the amended SSRA and the fair market value of the assets of the original SSRA, I believe, is quadruple or more of a difference.
I just have one quick question for you. So that Baker case, as I read it, I mean, there do seem to be some parallels here, but the thing that stands out to me is there were a lot of secret machinations by the lawyers in that case. As far as Saul Ewing goes, as I read the complaint, and especially where there was the call for that special meeting, I mean, you were aware of that, right? I mean,
I believe Saul Ewing, the planning for that was all secretive. We didn't learn about it until it was already set. Everything was set. It was fait accompli, more or less. We are going to go and do this
Is that in the current record?
I believe it is. And that they did that without knowledge. It was here, this is going to happen. That's when we got knowledge. We got knowledge from the Kasner parties after they had allegedly already enacted them, and for the Saul parties, they had meetings, and they admit at the hearing that they were the ones that planned. In the complaint, there's an inference that the Saul Ewing parties are the ones that arranged for this. In the hearing, they actually admit that, no, we were the ones that arranged for this special meeting because we wanted to enact these changes. And that was done all secretively, on working for the company, secretively planning with other parties in order to freeze out and take away rights from the minority shareholder.
I think we're going to have to leave it there and rely on your brief. And
Thank you.
We'll hear from, first, Mr. Burke, I believe.
Thank you, Your Honors. May it please the Court, Zachary Burke for the Saul Ewing appellees and its litigation attorneys. And I'll refer to them collectively during my comments as the Saul Ewing litigators. The trial court's decision here should be affirmed, and legal fees incurred by the Saul Ewing litigators in connection with this appeal should be awarded, because this is a textbook, black-letter anti-SLAPP suit that was properly dismissed as a matter of law. The complaint here was targeted at the Saul Ewing litigators' petitioning activity on behalf of their clients in connection with their representation of parties directly adverse to the appellant trustee in a pending shareholder litigation. And I'll refer to that litigation today as the shareholder suit. The Saul Ewing litigators, as the court is aware, represented the SZAWLOWSKI family companies in the shareholder suit, while the Kasner and Edward attorneys represented the individual defendant shareholders in the shareholder suit. Now, as I mentioned, this is a classic anti-SLAPP case. The trustee filed the shareholder suit. The ZAWLOWSKI companies then hired the Saul Ewing litigators to defend them in that suit. The Saul Ewing litigators proceeded to defend the case and engaged in actions taken to resolve an issue expressly raised in the complaint in that case, and then the Saul Ewing litigators were then sued by the trustee for taking those actions. Now, with that
to the
said,
extent that the Saul Ewing defendants assisted the companies in calling the shareholders to a special meeting to take a vote to ratify the 2018 amendment, how is that petitioning activity? Under Bristol Asphalt, everything has to be petitioning activity, and that just doesn't seem to be the kind of thing that the court has contemplated when it comes to petitioning.
yes, Your Honor. The case law is very clear that petitioning activity is supposed to be considered very broadly. There's case law we cited in our briefs where flying a helicopter over someone's property, taking photographs of the property is petitioning activity because a case was pending. Lobbying for legislation, writing a blog on the internet, all of that in the case law cited in our
Those
brief.
are all communicative activities. What is the communicative activity that's being done when you're calling shareholders to a special meeting?
Well, with respect, I do think some of those activities are conduct. Taking photographs is conduct.
I'm not saying it's not. I agree, it can be conduct, right. But why is this particular heart of the allegations against you? I think they may be covered by the litigation privilege, and I'd like you to address that, but I just in terms of the anti-SLAPP statute, because that has other consequences, I don't quite see how all of the alleged conduct involving your clients is petitioning.
Right, so
And
petitioning.
before you answer that, let me just add, you said attorney's fees are appropriate here because this is classic SLAPP. We've seen a lot of SLAPP cases. I've seen a lot of SLAPP cases. This is very different from the SLAPP cases I've seen in terms of, just a litigation issue involving business. It's not your typical SLAPP case at a minimum.
I understand that, Your Honor. I do think it is a typical SLAPP case because what happened here is the Saul Ewing litigators were representing these companies in an ongoing litigation. One of the issues directly raised in the complaint was this question of whether these written consents were adequately adopted under the rules of the companies. There's allegations throughout the complaint about that, claiming that the written consents are invalid, they should be deemed unenforceable. What the litigators then participated in was a meeting in order to address that issue that was pending in the ongoing litigation. Let's have a shareholder meeting, let's have votes, and we will moot this issue that was raised in the complaint.
Why isn't, to return to Judge Toone's question, why isn't that a litigation privilege issue and not an anti-SLAPP issue?
Well, it is both, and the distinction here, there's no inconsistency in Judge Salinger's findings here. The Kasner and Edwards conduct at issue occurred before the litigation was filed. So that was in anticipation of litigation. Here, the litigation was ongoing, and under the SLAPP statute, ongoing litigation, if there's petitioning activity in connection with an ongoing judicial proceeding, then the anti-SLAPP statute applies. That's exactly what we had here. The Saul Ewing litigators, all they did was circulate a notice of the meeting that was called by one of the individual shareholders, and they attended the meeting and took minutes at the meeting as litigation counsel for the companies while this issue was pending in the court. And that's the distinction. There's no inconsistency. The litigation privilege does apply, but so does the SLAPP statute with regard to my clients at least.
But one of the things they say in Bristol Asphalt is like the motivation, when we make this initial inquiry under the anti-SLAPP, under the special petition process, you don't look at the reasons why someone was engaging in activity. All you look at is this petitioning activity or is it not, right? The litigation privilege is different because I think then we can take into consideration the reasons why you're taking certain steps as attorneys. But you have to really sort of focus on the actions related to the special shareholder meeting and say, is all of that protected petitioning conduct? And I have a problem with that.
Your Honor, the case law I submit is very clear that the standard in connection with litigation is extremely broad. And if you look at the Plant case, it covers any action by litigation counsel in connection with advocating for their clients' positions in an ongoing litigation. And that's what this meeting was.
That's a little bit different, though, isn't it? Because in that case, yeah, it did say in connection with, but that was, the lawyers were actually articulating the position of the client in that case and getting sued for that. That's a little bit different than what's going on here, because your client wasn't in the position of articulating the position when putting together the special meeting. I mean, it seems to kind of step out of that role, don't you think? It's a little different.
I don't think they were stepping out of their role, but for this litigation and being litigation counsel, Saul Ewing would have not done anything with regard to this meeting. They wouldn't have been involved whatsoever. So all the actions that they took were in connection with the litigation. What they did was they implemented a strategy that was part of the litigation in order to moot an issue in the pending litigation. And I think that fits well within the scope of what's in connection with litigation. One other thing I just want to address quickly. I believe the Baker case is completely irrelevant to the anti-SLAPP motion based on the Bristol asphalt case here. The Bristol asphalt case says that the second path that the opponent of the anti-SLAPP motion can pursue to defeat the motion, that has been eliminated. So the motivations of the party for filing the claims is completely irrelevant here. The only question is, was this petitioning activity or in connection with an ongoing judicial proceeding, or was it not? And I think the case law makes that clear.
Okay, I gave the appellant an opportunity to bring to our attention any developments in the other cases. Is there anything you want to comment on that?
Your Honor, I can defer to my brother here. The only thing I will say is my understanding, and I am not litigation counsel in those cases, that the court has decided that the trust had waived its right to challenge the presumptive valuation amount. So the value is not at issue. It's stuck at whatever that amount is. Thank you.
Thank you very much.
Thank you, Your Honors. May it please the Court. I'm Chris Storm for the Kasner litigators. The Court should affirm the Superior Court's November 28, 22 order dismissing the Kasner litigators on the basis of the absolute litigation privilege. And I'll use first names with regards to the parties for clarity. Frank and Chester's actions to remove Stanley as manager of SZAWLOWSKI Packers and other actions were undertaken pursuant to a litigation strategy that was prepared and advanced by George Price, a senior litigation counsel at Kasner and Edwards, and who is currently representing Frank and Chester in the underlying shareholder suit. The strategy advanced Frank and Chester's shareholder interests vis-a-vis Stanley, the third shareholder, with the conscious aim that the actions taken could be defended in court if Stanley objected and brought suit. And, in fact, upon learning of the actions, Stanley immediately retained his own litigator and threatened suit even before the window for him to vote no on the actions had closed.
But the problem with that argument, you can say it's part of a litigation strategy, but you're essentially saying, we were advising, first of all, were you advising the companies or were you advising just Frank and Chester?
No, and just Frank and Chester, which is clearly set forth in the very first letter dated December 4, 2018, that Attorney Price had sent to Stanley, which is appended to the complaint and is in the record here.
Kasner eventually then later represented the companies, is that correct, in litigation?
In litigation, Kasner later represented the companies for a short period of time before Saul Ewing began representing the companies.
So in applying the litigation privileges, courts draw a line between actions preliminary to litigation, which generally protected, and ordinary counseling on business matters. Your argument here seems to be, we were advising Frank and Chester on this business matter, but we knew that Stanley was not going to like it and probably was going to sue, right? And so therefore, we consider this, as a part of a long-term litigation strategy. I don't think that's how the litigation privilege works. Just because you do something that you know is going to result in litigation doesn't necessarily make it preliminary to litigation in this sense. So I guess that's the problem here. The cases you cite involve ongoing claims or demands by other people that are being responded to. Here, you are representing a party or parties that is initiating a conflict, and that seems to be really an overbroad application of the privilege.
I'll go one step further in my own impertinent way and say that, let's say this was an illegal freeze-out. Can a law firm to use the appellant's term, conspire with the parties on an illegal freeze-out and map out the strategy for defending it. And then when it is challenged, they say, oh, we can't be liable because litigation privilege.
So, Your Honors, I think the answers to your questions are in both the context established by the letters appended to the complaint and in the Barnes versus Johnson-Neisser case. Let me explain. The context is very important, right? So Joseph, Stanley's son, was an employee at the farm with an aggressive and confrontational relationship with Chester and Frank. And the relationship was so hostile that it resulted in termination for cause and later litigation on that issue. So that context, that intimate familiarity and knowledge in the context of this family business is very important to understanding why when Frank and Chester retained a litigator to chart the course that they then undertook, that's why they did it. They did know that they were going to get blowback. Now,
But did they still, at that point, they still owed a fiduciary duty to the minority shareholder, though, right?
And what the Barnes case says, Your Honor, so two things. First of all, the Kirker case well, let me back up. As to the Barnes case, that's important to your question, Judge Toone, and I'll get to your question in a minute, Judge Hodgens, because Barnes was pre-litigation also. That is a similar situation in which the court applied the litigation privilege to claims based on lawyers preparing and advancing a litigation strategy to help a client oppose a business partner's demand to be bought out from the business. Kasner similarly prepared and advanced a litigation strategy to promote Frank and Chester's interests as majority shareholders. And what the Barnes court said is that the lawyers can't be liable for that even if the underlying client's conduct could be a source of liability for the client. The lawyer still nevertheless, even in a pre-suit context, gets the benefit of litigation privilege where they are charting and designing a course of action to promote their client's interests, which may be, and in this case, were adverse to another shareholder.
I want you to answer my colleague's question, but just on Barnes, which is an unpublished decision, the litigation privilege applied there because the defendant lawyers represented a 50% shareholder of a dental practice, right, where against the other shareholder who wished to cease practicing and had made a demand to the corporation that should be bought out, right? So there they were responding defensively to a claim of an imminent litigation by another party. Here, you all were assisting Frank and Chester in kind of putting this dispute into motion. So it seems a fundamental difference there.
I disagree, Your Honor, because what we had here was an agreement among the three surviving shareholders that if one of the three of them were going to be incapacitated, they would step back. That's expressed in the SSRA and in the agreement to value the shares at $4 million. And factually, what's expressed in the letters attached to the complaint is that Stanley had unfortunately suffered severe dementia and had become incapacitated and had not stepped back from the farm. He maintained his position as director and officer of Packers. So that was one of the very important issues that the Kasner litigators were helping Frank and Chester respond to and navigate.
Once you start drilling into the facts and talking about how context is critical to understand these legal principles, my radar goes up a little bit in terms of how could Judge Salinger then resolve these issues as a matter of law?
Your Honor, because all of the context that's necessary to resolve these issues is supplied in the letters that are attached to the complaint by the plaintiff. So the litigation privilege, I think it's very clear that there was a highly antagonistic relationship here. The parties were proper to foresee that litigation was likely to occur. Within 6 days of Stanley receiving information that these actions had been undertaken, he had retained litigation counsel and sent back a letter that said, "We're prepared to file suit." And what was Frank and Chester's response to that? Through counsel, Attorney Price, they said, "Let's go to court." So I think the letters tell the story here, Your Honors. They provide all the context that's necessary There was an appropriate anticipation of litigation. It was immediately threatened. It did eventually get filed, and the response was appropriately postured to respond to litigation. Justice Hodgens, you asked, I think, about fiduciary duty. Baker is very different here. I think, as Justice Toone acknowledged earlier, in Baker, the lawyers who allegedly owed the fiduciary duty were corporation counsel, not the situation we have here, where Attorney Price was a litigator representing two shareholders. Two shareholders who may not be aligned with other shareholders are entitled to retain their own separate counsel, and that's exactly what happened here, and I would submit that based on the letters, it's a very clear case. And, Your Honors, I appreciate that I'm running low on time. I will also just say that the lack of damages that this panel had observed earlier in the arguments is another separate and appropriate basis to affirm the dismissal of Kasner.
So I'm glad you're addressing that. It seems like an unusual basis to dismiss a lawsuit, to sort of say, well, you haven't plausibly alleged damages. He claims damages, but you haven't kind of spelled out the theory. And I just want to, are there cases that have dismissed lawsuits just on the basis of failure to allege damages in this kind of corporate context? I would assume there'd be always going to be some damages in this kind of shareholder, minority shareholder dispute. So I wonder if you have any authority that kind of bolsters this position.
So, Justice Toone, I believe if you look to the record here, that really spells out the damages issue and why it's not as close as it might appear initially. At oral arguments below, the motion judge offered the opportunity to point to where in the complaint it alleged damages, and the trustee wasn't able to do it. And moreover, in responding to the anti-SLAPP motions to dismiss, the trustee wrote and repeated today in oral arguments before this court that he was suing on the prospective loss of rights. So this is all forward-looking, it's not concrete, and it doesn't set forth the prima facie case.
Same question I asked the plaintiff. If we were to send this back and neither agreement applies, how does damages get resolved? Is it just a battle of the experts on what market value is?
Justice Milkey, I don't think there are any damages if this gets sent back. I mean, the agreement between the brothers setting the $4 million shareholder price was not challenged in the underlying litigation, right? That was an agreement that was entered into by all four brothers, all four shareholders when they were alive. I think it's very clear that the price for the shares, just as John SZAWLOWSKI received when he passed away, is $4 million with the adjustments called for in the documents.
And if that's different from the actual market value of the shares, you're saying that the trustee's locked in?
He's locked in, Your Honor, because he had an opportunity to seek a contractual appraisal pursuant to the SSRA and didn't exercise his rights.
But that's the issue in one of the other cases, correct?
It is. I believe it's already been resolved in favor of the companies, though.
Just one last question. So would you agree that though the shareholders all have a right to hire their own counsel, they still owe a fiduciary duty to the minority shareholders, right?
An attorney for particular shareholders does not owe a fiduciary duty to other adverse shareholders. The fiduciary duty that closely held shareholders may owe to each other does not extend through their lawyers to the other opposing adverse shareholders. And that, the citation for that is, I believe that's the Baker case.
There's no alarm bells that go off with the lawyers that say this is a closely held corporation and that we should tread very carefully here as far as giving advice to the majority to do something to the minority?
Well, Your Honor, I think that's why we have an adversarial system where people are entitled to retain counsel to advise them on their rights. And it's the parties who are exposed, as the Barnes case indicated, if ultimately they take action that is impermissible vis-a-vis their co-shareholders. But the attorneys are entitled, particularly under the formulation of the litigation privilege recently expressed in Bassicus, where it's strong, broad, and ought not to be refined by just, fine distinctions, the lawyers are entitled to the maximum amount of freedom possible under the ethical rules to advocate in favor of their clients.
I think we're going to have to leave it there. As with the other cases today, excellent arguments by all sides. I'm just going to repeat the suggestion I made earlier, namely that we will do our best to resolve the narrow, if complicated, issues in front of us. I would encourage the parties to keep talking, because in light of this case and all the other related cases, you guys can keep this going for a long time if you want. And it seems like there might be a number to resolve this. I'll just, before I cross too many lines, I will leave it there myself. So the case is submitted.
Thank you, Your Honors.
We're going to take a break only long enough to set up the connection on the internet for the next case.
All rise. Let's go stand in recess. You're very welcome, guys. God bless you both. Mr. Carter, you need a hand with anything over here? Need a hand with anything over here?
Test, test, can you hear us?
I can hear you.
Very good.
Hello, Attorney Klein. Can you see and hear me?
I can. Good morning.
Good morning.
Afternoon.
Can you see and hear me now?
Yes, I can.
Okay. And what about now? Can you see and hear me?
It's a little delayed, but I see you getting into your seat.
Okay. So there's a delay between
No.
the video and the audio?
Actually, now I see myself twice. Now I see you again, but it keeps flipping back to a second window of me.
Yeah, that's expected behavior. What it's doing is it's showing you what's going out on the Zoom. So there's a switching, a camera switching that happens. Yeah, so when somebody in the courtroom is speaking, you'll see that person on the second window, but when you're speaking, you'll see yourself.
Okay.
All rise. Court is now open. Please be seated.
Thank you all very much. We are back on the record with a consolidated hearing of two cases, 2023 P902 and 2023 P164. Both of the cases are Robert Leaf versus James Driscoll II. Let me just go over a few ground rules before we start. We are going to hear the two cases together. We have given each side 20 minutes. I would ask you to address the case in chief first. By the case in chief, I'm referring to the second appeal post-trial. We will ask questions. The floor is yours to begin with, Mr. Driscoll, but we will ask questions of you at various points. At some point, either after 15 minutes has gone by, if we're done with our questions, or after we're done with the case in chief, we will then turn to the second case, which was actually the first in time appeal. I'm sure some issues will come up as we're going through this, but why don't we go ahead and start? So, sir, the floor is yours. If you could stand at the podium, please.
Excuse me. Good morning. May it please the court. James Driscoll for myself. If I can please have 45 seconds. This case begins 2019 when I consulted Attorney Cohen to sell my property, telling him in confidence I wanted to sell my land to a developer who would pay to maintain Driscoll Way, clean up the 2,000 square foot pile of construction debris between lots 6 and 10, clean up the junk around the circle, and build expensive homes to raise the value of my property. Not 1 year later, Robert Leaf met me on my driveway and told me Cohen had sent him to buy my property. And Cohen told him, I want to sell the land only to somebody who will do all these things. The next day I got an offer from Leaf stating all of these things that Leaf calls his contractual obligations that must be performed at Leaf's sole expense. That offer was drafted by my fiduciary, Stephen Cohen. The offer is subject to addendums. Time is of the essence, making each addendum subject to a condition subsequent. Addendum number 2 says a well is to be installed by 11/23/2020. There is still no well. This is a dead deal. In Vickery, the seller is to know by date certain if the deal is on or off. It is off. Judge Wilkins, 3 years ago today, said neither party breached, neither can sue. Your Honors, I simply do not want to be Leaf's neighbor. That is the only thing I ask of this court. I do not want to be his neighbor. I cannot imagine why Leaf wants to be my neighbor so badly, but that's what he testified. I can't put my kids through a lifetime of litigation with Leaf like I have endured. When he sued my son, Leaf told him, "I've got tons of money and lawyers. I can sue you and your dad until you are below broke."
Sir, can I interrupt for a sec? In terms of the neighbor issue, it's my understanding from the record that Dr. Leaf has already built a house for himself elsewhere down there.
Oh, yes.
So presumably, we can hear from his counsel afterwards, but presumably his interest in this and Lot 10 is more economic at this point. Is that wrong, too?
He's always said he does everything in his best financial interest, people aside. At trial is when he testified that he wants to be my neighbor. At trial.
Can I also, sir, ask you a factual question? We, of course, need to look at the trial record and in light of the jury's findings. And on November 25th of the relevant year, I can't even remember what the relevant year is, but I remember the dates. On November 25th, the day after the PNS was supposed to be signed,
yes,
Dr. Leaf, through his counsel, indicated his willingness to waive condition number 6.
Correct.
And you said, essentially, I'll paraphrase, too late, the deal's off.
Yes, sir. No deal.
Based on that evidence, couldn't the jury conclude that you had simply changed your mind since he had, to use a colloquial term, caved on condition number 6, that you had changed your mind about selling the land and come to the conclusion that that was your intention, you were happy to let condition 6 blow up the deal?
Your Honor, a year after this, he sued my son to get that restriction. He went to court and used forged evidence to say that my son owed him the restriction. Could I read this paragraph? It includes that information.
Sure.
I'm sorry, I don't know what I'm doing here. Sorry. Leaf claims unilateral retroactive waiver of his contractual obligations. This actually happened at sidebar when the judge called him up and asked him, "I don't see any signs of waiver by Leaf. I don't see any signs of waiver by Driscoll." To which his lawyer replied, "When you file a lawsuit, your contractual obligations disappear. We are here to enforce Driscoll's obligations." I'm sorry for my tone. Leaf cannot unilaterally, retroactively waive his contractual obligations because before and after Leaf sued me, I said, "Drop the restriction and I will sell." Leaf refused. He threatened my son for a restriction. My son refused. Leaf sued him, swearing to the court with forged evidence that he thought my son already agreed. When my son still resisted, Leaf called his law school to try to get him expelled, and he called the bar to tell them my son should never be allowed to practice law. He did this again in the middle of last week. And when my son still resisted, he sent people after his mother the day before Leaf and Michael's trial. I cannot retroactively waive all these things that Leaf did when he refused to close without a restriction for 2 years. And I can't retroactively waive all the surgeries I've had, hip, knee, back, For the past 2 years and from now on, I have to sleep sitting upright because I had to continue tile installing to pay for food, lawyers, and land taxes for 3.5 years because my land is under a Liz pendants while Leaf did nothing. He accrued no rights. No well, no deal. The OTP says there is no recourse to either buyer. We are still in the OTP stage. On 11/24, Leaf had been given the opportunity to pay $145,000 and sign a P&S to enter an agreement. The agreement had a specific performance clause. The OTP does not. Leaf got specific performance. I asked for an equity hearing, and the judge refused. He said Leaf asked for specific performance, so that's what he gets. I didn't have an equity hearing on clean hands or my 55 other defenses. Leaf got to be king for a day. 2 weeks before, I'm sorry, I'm getting random here. Leaf also got to pick the evidence timeline, which he curtailed to 10/14 of 2020 to 12/1 of 2020 when he filed suit. Nothing about the hearings afterwards where he did use these addendums, that at court he said he waived that he waived them on November 25th. He only agreed to waive number 6. He never agreed to waive anything else. He never pled waiver. He never pled ready, willing, and able.
Can I just interrupt you on the conditions? You've mentioned the well.
Yes, sir.
In terms of the other conditions, so not 6, not the well, what obligations are you arguing that he had?
Okay, number 1, 2, and 3, the MESA, the septic, and the well, all due by 11/23. He did nothing. He did emails and lawyers.
Okay, but on the MESA.
Yes, sir.
His argument is that this was a condition in his favor to evaluate whether the land could be built upon or not. I understand the argument on the well, but on MESA, how did his non-compliance with that condition affect you?
I have dates certain that he was supposed to comply with. He complied with 0, 0, 0. The MESA he put in the hands of a third party, MNHEP or whatever it is. He never filed an application. He went to court and said that addendum number 3, he used this MESA clause, he used to try and get an HDC permit. He said that if it was never included in the OTP, he never mentioned it until the hearing, well, when he filed for the hearing. At the permit motion hearing, he said that he needed HDC approval because if he was turned down by HDC, he was going to end the litigation and walk away. He was trying to get the court to give him another way to get out of this deal that he had already broken. So he says that he waived all these addendums November 25th. Or December 1st is when he bullied the judge into saying that his contractual obligations disappear when you file suit. We are here to enforce Driscoll's obligations. He did not waive them ever. He brought up the waiver on 1/8 of 2023. He got 2 trial lawyers. They came in 2 weeks before trial, and all of a sudden, oh no, the OTP is out. That died. That died on 11/24. I don't even know what you're talking about. We are going with, I call it a phantom offer, because he never showed it to anybody. On 1/8, he promised the judge that he would show him at the next joint trial or motional meeting, I don't know. On 1/18, 2 business days before trial, he didn't show him then. He said he'd show it at trial. Partway through trial, the judge says, "Where is this offer? You told me you were going to show me this subsequent modification. Where is it?" oh, it's coming, it's coming, it's coming. It never showed up. It was just a scam. He used that to get the judge to throw out all my evidence, because everything that happened from December 1st until 1/8 of 2023, when he brought in the lawyer to say that they had this brand-new offer that they were going to enforce, and the old offer died, of course. He convinced the judge that all of these pleadings and everything else never happened. The judge could not imagine why he would use number 3 for a permit motion if he had already waived it a year before. He could not understand why Michael was sued. Mr. Leaf, being king for a day, besides picking my evidence timeline, I was not allowed to present any affidavits, no public hearings, motion hearings that occurred during this, because he said he convinced the judge that we're going on this phantom offer where all the addendums were waived. And the judge couldn't make up in his mind, how can he have hearings on stuff that he waived? Absolutely frivolous case. That's his style. It's his MO. I'm sorry. This new phantom offer, listen closely, I think the plaintiff made the decision when they filed, Oh, come on. Oh, I'm sorry. The trial was held on this sentence. Listen closely. Unless your client is willing to drop the restriction, it sounds like we're still at an impasse. The whole week leading up to 11/24, when the PNS was supposed to be signed, my lawyer sent Leaf a PNS with 44 new items in it. Mr. Cohen said he expected 6 or 8 more pages of terms, but that didn't occur. Anyway, so every email said, it sounds like we're at an impasse, Michael won't sign. Now all of a sudden, this sentence is the brand new phantom offer that the trial was held on. Unless your client is willing to drop the restrictions, it sounds like we're still at an impasse. 11/24, 2:06 p.m. Both the demand to continue the trial past the deadline and a refusal to continue past the deadline. One sentence, Schrodinger's repudiation. In the brief, Leaf admits that he wasn't going to sign until Buckley drafted a PNS for him. But see Fariello. The buyer must present a PNS they're willing to sign on the PNS date. When I presented this to the judge, he said, buyers miss PNS dates all the time. This whole case is about Michael not signing the restriction. Leaf has been pushing restriction, and then he told the judge, I never heard of Michael, I don't know what you're talking about. I wasn't allowed to bring up the fact that he sued Michael. He sued my son to try and make the court make my son give him his land through the restriction.
On the day after you argue the offer expired, he put in writing that he would sign the agreement without condition number 6, i.e. without any restriction whatsoever. At that point, why couldn't the jury conclude that at that point you had just changed your mind about selling the property because you won on the issue of condition number 6?
Too late. 11:23 at midnight. He's supposed to have a well in. He's supposed to have septic. He's supposed to have Misha accomplished. He never started anything. He did emails and lawyers. He did nothing. He has accrued 0 rights. I'm sorry for my tone.
Sir, there is an open motion in front of us that asks to brief subject matter jurisdiction. What, if you know, what is the argument you want to submit briefing on about why the Superior Court did not have subject matter jurisdiction. It was your motion.
I don't understand.
You filed a motion arguing to brief the issue of whether or not the Superior Court had what's known as subject matter jurisdiction, which is a fancy term for the power to hear the case. And I'm assuming that what was behind that motion was likely an argument that it was the land court that should have heard this case, not
Yes.
Superior Court. Is that the argument?
Yes, sir. I've been tied up in a Liz pendants for 3 years because on the verified complaint, number 2, Mr. Leaf wrote, Leaf sent Driscoll a draft P&S. Later, he admitted that was false. But he's 50 years in the real estate business, and that's what you gotta say to get a Liz pendants. And that's why it's there. Like all this other stuff.
Hey, sir, could we...
When my son...
Go ahead.
When my son was sued by Leaf, Judge Cosgrove threw out count 3 of the amended verified complaint. I don't know if it was docketed correctly. He told his clerk to throw the whole thing out, and she did not. I don't even know if this court knows that count 3 was thrown out. That was supposed to, the ABC is supposed to contain no omitted facts and no falsities. If count 3 is thrown out, why isn't the whole ABC thrown out?
Okay.
The verified complaint is full of falsities.
If we could turn to the earlier appeal, unless not hearing any questions on the appeal in chief, why isn't that case, this appeal on the denial of the motion to dismiss, why isn't that appeal what's called moot now? Because this case is already, that was a pretrial motion, this case has already gone to trial, you have an appeal of the trial result, why isn't the earlier appeal moot?
The special motion?
Yes.
Because it was never heard, Your Honor. They filed, the ABC was filed at the end of the special motion to dismiss Liz Pendant's case, when Judge Wilkins said 3 years ago today, I should, the legislature says shall, dismiss. But for judicial efficiency, I'm sure Leaf will come back with an amended verified complaint to clean up these omitted facts. If there are omitted facts, I thought the verified complaint gets thrown out. However, Leaf was given 2 weeks by this judge to come back with the amended verified complaint. Wilkins did not rule on the amended verified complaint. He only let them file it. I don't know if he kept it in the back of his mind, but anyway, he did not rule on it at all. I've never had a chance to fight the special motion. I think this trial thing, or it should have been thrown out long ago. Judge Gilday, 3 times, during 3 different hearings, over the course of a year and a half, kept telling Leaf, if everything is not waived, your action fails. Leaf replied, certain terms are still live. The contract is enforceable as written, so why not toss the case? I don't know. I have not had anything in 3.5 years be affirmed in my direction. I've been denied everything. I know he's got more lawyers and sorry. I don't know. He even sold, okay. After Leaf sued my son, I ran into Webster, who was Leaf's architect. I've known him for 35 years. I had agreed to sell him 10D subject to Liz pendants. When Leaf found out, Leaf insisted he broker the deal. He stepped in the middle, brokered the deal in which I was supposed to get $250,000 from Webster. He was getting architectural discounts on the house. When Webster agreed, Leaf told me that Webster backed out and kept telling Webster that I was in and settlement was imminent, and secretly sold to Webster, and then lied to me in the court that it never happened. And that's why I never filed a special motion sooner, because I was being defrauded. In this assignment, Mr. Leaf sold all his rights in the OTP to Webster for 6 months. He and Cohen and Attorney Quick seemed to be somewhat in cahoots, as Cohen, who was Webster's lawyer, and also Leaf's, he's whatever. He told Leaf that if he waited a little longer, the Webster assignment would run out and he'd go back to court and continue the trial. But for 6 months, he had no standing in this court. He sold his rights. How do you come in here to the court and say, I have rights in this case, when you sold them? So he took the $250,000. I got nothing out of it. And then we just picked up the case again.
Sir, your time has expired. If you could just wrap up.
Okay. Mainly, I don't want Leaf to be my neighbor. I don't know why he wants to be mine. This is... Okay, regarding the special motion, the amended complaint is the exact opposite of the trial theory, like Gilday said. Transcript 2, page 29, waived everything versus waived nothing. Shoot. In the OTP, an offer to purchase is an agreement to agree. If you have a contract anticipating a future signing of another contract, it is only an agreement to agree. As Leaf himself put in his motion, page 85, transcript volume 2.
Sir, we understand the gist of your argument. I think we're going to have to leave it there, given the time has expired, and we need to hear from Ms. Klein.
The other thing about the AVC, the verified complaint had 11 facts in it. The amended verified complaint had 46 facts, 35 more of those facts.
Yes, thank you, sir. Ms. Klein, the floor is yours.
May it please the court, Lauren Klein, representing Robert Leaf in this matter. As the court has already noted, the case in chief is an appeal from a unanimous jury verdict after a 4-day trial. And what is before you today, obviously, is a review for error. A lot of what Mr. Driscoll has just discussed is way beyond the purview of this appeal. And to be as generous as I can be, I think represents a lot of misunderstanding of legal matters that have happened during the last several years in this case. I'm not sure that generosity is actually warranted, and I will get to later why I believe sanctions are actually appropriate here. But I will start with the basics, which is that Mr. Driscoll was represented by counsel at the trial and in the pretrial matters preceding it, and worked with the court and with Leaf's counsel, who was not me at the time, to draft and come up with acceptable jury instructions and jury special verdict slip. The Judge Gilday, was meticulous in making sure that he put on the record both sides' counsel's agreement that they were satisfied with the jury charges and with the special jury verdict slip. So when Mr. Driscoll complains that he was not permitted to argue certain things or have the jury decide certain things, his only recourse really is with his attorney, because he was represented and his attorney agreed. Most of what he has complained about in his papers putting aside some of what he said today, which I found hard to follow, he really doesn't have a right to argue about now because either his lawyer never brought those things up in the pretrial period or during the trial and preserved his objections, or because, worse, he actually agreed.
Counsel,
Yes.
assuming you can see me, I'm Judge Milkey.
Yes.
Ordinarily, after a case goes to trial, the appellant can no longer argue that the appellee's case fails as a matter of law unless a motion for a directed verdict has been filed at the appropriate times. From what I can tell from the transcript, that did not occur here, yet you make no argument about this point. Have you waived the issue of waiver of the as matter of law claims?
No, I have not waived it, and I would say now that's a terrific argument in addition to the other ones that I have made. I think I was focused more on factually going through a voluminous 4-day trial transcript.
Well, I've read every page of the trial transcript. I've read every page of the record. And part of the argument throughout the case was that as a matter of law, Mr. Driscoll could not comply with Condition 6 because, at least interpreted in a particular way, it required a deed restriction on Lot 6, and he was incapable of providing that because his son had a 20% share.
I can respond to that.
Assuming arguendo that was a reasonable interpretation of Condition number 6, why isn't the implication that he could not have complied with Condition 6 as of November 24th of 2020?
I'm sorry, I didn't follow the gist of the question you're asking me. As of November 24th, why?
Let me start over on the question because it's an important one. A jury readily could have concluded that as of the end of November 24th of 2020, Mr. Driscoll was no longer willing to comply with Condition number 6, and in fact was making a reasonable argument that he could not comply. So the question is, how was the contract repudiated as of 11/24/2020 as opposed to Condition number 6, if you will, repudiated? Because the case law seems clear that to have repudiation of a contract, the term at issue has to be central to the contract, and that begs the question of whether Condition number 6 was central to the contract or not. And a decent argument can be made that subsequent events showed that it wasn't central because your client dropped it the following day.
Mm-hmm.
So where, as a matter of law, to the extent those issues are not waived, where was the repudiation prior to the end of 11/24?
Okay, I have an answer to that, and that is in the facts. It's that on November 24th, Driscoll and his attorney had drafted an agreement that added restrictions that Leaf's counsel did not believe were even required, but had been put in. In other words, the interpretation given to Clause 6 by Driscoll's side was the only reason he wasn't able to provide a P&S that complied with the OTP. It was certainly within his capability, his lawyer's capability on that day, to draft and provide to Dr. Leaf a contract that fully complied with the OTP. The interpretation that later would have possibly followed Condition 6, we can only guess, but it was not the case that he needed to complicate matters. And what happened was that he said, I cannot have my client sign a P&S that contains deed restrictions. However, Leaf had never asked for deed restrictions.
How do you explain the binding on successors language if it didn't encompass a deed restriction?
There isn't an answer to that. Maybe it was poorly drafted. And maybe the answer is that Driscoll and his attorney should have said, cross out those two words and we have a deal. But I think what happened, and I think it's pretty clear, is that Driscoll had decided to use this as an excuse. And the reason I say that so confidently is when you read the emails that transpired between November 23rd and November 25th, it's clear that Driscoll's side keeps chipping away. First, there was a draft of a P&S, but it was 100 feet was cut back to 50 feet. When Lee first said no, he first said no, and then he said yes. And then Driscoll said, no, that's not good enough. You have to drop it altogether. But meanwhile, it was Driscoll's side who had drafted an agreement Driscoll wasn't prepared to sign. Leaf was never given a contract to sign, a P&S to sign, that tracked the agreement in the OTP. And in fact, at trial, Driscoll testified he was not willing to sign a P&S that involved, he's testified to a number of curious things. He was never going to be willing to sign anything that involved his moving junk off of Lot 6, even his own junk off of Lot 6, and which would have been a personal obligation. And also, he testified, I find this a particularly curious fact, that he expected Leaf to remove this junk that belonged to a friend of his son's, which, I mean, how was Leaf supposed to do that? Anyway, a lot of this is
while we're talking about
extraneous.
other conditions, could you address the well issue? Because that seems to be the one other restriction where he's saying, had the deal fallen through, at least I would have gotten a well.
But that, I'm surprised that the court is entertaining that, frankly, that argument, because that condition says to the satisfaction of the buyer. It's supposed to be a well that, I don't know the language, engineering language, but it's supposed to perform in a certain way, satisfactory to the buyer. Clearly, conditions 1 and 2 say on their face, satisfactory to the buyer. Just like in this case, Sheila Morgan McCullough versus Chase Great Marsh, LLC, an unpublished decision that I attached to my addendum in the first appeal. It's very clear that when a condition is only for the benefit of the buyer can certainly waive it. In that case, the trustee, who was the plaintiff, wanted to purchase certain land in order to combine it with land she already owned and then subdivide. Eventually, she abandoned that idea, and that did not vitiate the contract. I'm sorry, that did not invalidate the contract.
This is an unpublished case you're referring to.
It is, but it has I'll give you the number, miscellaneous 20-000208, and that is Judge Vey.
So you're talking about a land court case?
Correct. Yes. But it lays it out and it cites cases from your court as well as others. And it makes it very clear that when a condition is solely for the benefit of the buyer can at any time abandon it without giving the seller an excuse to get out of the contract.
Could you address the time is of the essence language? Because you have emphasized many times in your brief that the contract did not say that the offer to purchase was conditioned on the signing of a P&S. Do you have any cases that say that the absence of such language makes a difference when the time is of the essence? Cases seem to interpret such language fairly strictly.
Ferguson versus Maxim. I don't have the site, but it's in my papers. And do you want me to come up with the site right now?
No, we can find it.
Okay. But yes, Ferguson versus Maxim makes that exact, I'm not sure that it talks about time is of the essence, but it points out the difference between the set of facts it was dealing with versus McCarthy-Tobin, which had subject to language, making the P&S a condition subsequent. In our case, the OTP does not use subject to language with respect to a P&S, and in his very well laid out opinion, Judge Wilkins, in his decision number 11 in the Superior Court docket, which was the denial of the special motion to dismiss, as well as a denial of Leaf's motion to obtain permits or to apply for permits, he lays out all of the different ways in which Leaf could prove his case. And one of them is that because there was no subject to language, the P&S was not actually a condition subsequent, and since neither side signed it, it could easily have become, here he writes this, the consequence of both parties' non-performance may well be that the OTP itself is enforceable directly, and there will simply not be a P&S agreement because the time for signing one has passed. In that case, Leaf has a supportable argument that, as a binding contract, the OTP remained enforceable because he is not in material breach. If so, then Driscoll's repudiation of the contract, even after Leaf abandoned paragraph 6, was a breach that entitled Leaf to sue for specific performance. I think that's important. I think that means that the November 20...
Isn't that the theory, though, that the jury did not actually address because they resolved it based on repudiation of the offer?
I think the important answer to that question, Your Honor, is that Driscoll's attorney did not ask for a jury charge about waiver, there was a jury charge about repudiation that both sides agreed to, but he didn't ask for anything having to do with the issue of Condition 6 and whether it was waived or when it was waived or any such thing. Both sides, by the way, you know this, you read the transcript, both principals in this case, both parties testified about the conditions and whether they believed them to be for their own benefit or not. In fact, Mr. Driscoll, I think this is important, Mr. Driscoll seems to have completely misunderstood that conditions 7 through 10 were written as permissive to Dr. Leaf. He was permitted to improve the driveway. He was permitted to put up a flagpole. There was no obligation. And if Mr. Driscoll wanted those to be contractual obligations, as he continually says in his papers he believes they were, his lawyer, his real estate lawyer at the time, should have said, no, I reject this offer to purchase, but if you change the language to make it an obligation, then there's something in it for me, and I'll agree to it. But he agreed to it the way it was written.
Could we turn, first of all, to the subject matter jurisdiction open motion to brief that issue, which you have filed in opposition to? We heard clarification today that this was based apparently on the argument that only the land court would have jurisdiction.
Your Honor, I actually I'm a little embarrassed to say I don't know what you're talking about. I don't think I did put in an opposition to a subject matter jurisdiction argument.
No, it wasn't to the argument, it was to the briefing of the issue of subject matter jurisdiction.
Okay, then maybe I missed the argument because this is coming at me without my awareness of it. Can you just tell me what paper it's in?
I don't have the docket in front of me, but perhaps I'm misremembering it, but my recollection was that a motion was filed to submit a brief on this. You opposed it. There was a response to your opposition saying it can never be waived, so we should do it, and then the matter dropped in terms of the briefing, but it is still an open motion.
Okay.
But
Yeah, there is.
And this is not the amicus?
Yeah, it's an opposition to defendant appellant's motion to file a supplemental brief. So,
Oh.
4-page opposition served on March 29th, 2024.
is it signed by Attorney Klein?
Yes.
Yes.
We talking about the same document here?
I don't know. Let me look.
Respectfully opposes the motion, file a supplemental brief, arguing that
I'm
Nantucket
pulling it
Superior
up.
Court.
I apologize, Your Honors. I really do, but let me just take a fast look. I guess I never actually opposed on the, oh wait, hold on. Case law is clear that issues raised for the first time on appeal are not entertained and will be deemed waived. Of course. Okay, Mr. Driscoll is not even, I'm sorry, Your Honor. Mr. Driscoll has not even hinted at how a superior court located in Nantucket could possibly lack subject matter jurisdiction over an equity action concerning the sale of Nantucket real estate. While the land court may have had concurrent jurisdiction, it clearly did not have exclusive jurisdiction so as to render void the superior court judgment which entered following a unanimous jury verdict. And yes, this was just a lapse in my memory.
Okay.
NGLC 185 Section 1 states concurrent jurisdiction.
Well, there is obviously some degree of exclusive jurisdiction in the land court in terms of affecting the title of registered land. And I assume, were we to allow such supplemental briefing, it would go to that issue. And the only thing we need to resolve after this argument is whether or not to allow any briefing on that. But in any event, why don't we turn to the, if you will, the satellite appeal on the motion to dismiss?
The special motion to dismiss, the appeal number 1. Yeah, I mean, it really is moot at this point because the only thing that Leaf needed to prove on, I actually do want to return to the other case in chief, but I'll address this quickly.
I'm afraid your time is up on that, counsel, but if you can turn to the satellite.
Appeal number 1. Okay, it's that the whole issue before the court on that appeal was whether the verified complaint was frivolous, and and that there are so many reasons why it wasn't, not least of which is that there was a joint motion, a joint pretrial memorandum signed by both sides, and there was a stipulation contained in there with a set of facts. Those facts alone made out a case for the lis pendens. So it was, even by that time, essentially the parties stipulated in that joint pretrial memorandum that there was an offer to purchase real estate, acceptance of the offer, a deposit check for consideration, and repudiation in the form of a request to return the deposit. The jury's verdict that came subsequently obviously provides even more support for all of the court's prior decisions that the amended complaint was not frivolous. I would like to just add that one of the problems with these two appeals and with the Driscoll's other appeals is I think that there is a real misuse of the judicial system that I believe this court should take seriously. And that is that despite what Mr. Driscoll said during his argument, it is actually the Driscolls, father and son, who have been constantly filing motions for reconsideration, repetitive motions. The special motion to dismiss, he actually got 4 bites at that apple. I don't know how he can say it was never decided. He argued it before that court, before Judge Wilkins, and then 3 times before Judge Gilday, 4 times. He has brought a federal lawsuit based on all of these same events. His son has brought an independent lawsuit in Plymouth Superior Court, which I just got a decision days ago, successfully dismissing it on my motion to dismiss, and already he has filed a notice of appeal as well as several more motions to amend the complaint and alleging all sorts of tort damages for Leaf having sued him. Meanwhile, Leaf's attorneys added Michael Driscoll to the lawsuit for a nanosecond. He was added as an alternative count 3, and Driscoll moved to dismiss and was successful. That was a matter of months. It was all over.
Counsel,
and yet,
I'm going to cut you off. You're covering stuff that is in your briefs.
Yes.
I have to say, again, having read every page of this record, there's some fairly untoward behavior on both sides of the V, and I understand the arguments you're making, but when there are documents in the record, and frankly, I'm not even clear how they made it into the record, but about, from the client to one of his lawyers saying, can't we sit on this for 2 years because property values are still going up? It makes the hair on the back of your neck, if you're a judge, stand up. So I will leave that there.
I understand, Your Honor. As a final word, though, I would just want to point out the high standard of review for a jury verdict. The jury was given all the facts and made its decision. And one last thing is, as for the motion by Driscoll to allow him to file a supplemental appendix number 7, I want the court to be aware that contains an email exchange that is marked confidential settlement discussions that does not belong before the court, and you should not accept it.
That was not in the record below?
It was not in the record below, no, and it shows up. It's actually beyond the point that the court below had deemed the relevant time period. It's subsequent to litigation, and it was conversations between 2 prior counsels on both sides trying to settle this matter. Last thing, I promise, is that one of the problems with reviewing these briefs is that every reference to the record turns out to say something different from what Driscoll says it says.
Well, counsel,
okay.
We have read the record, so we were able to police that one. Let me just close by saying this is reminiscent of what I said in the last case, which you may or may not have listened to. At this point, this controversy seems largely about money. If I understand this correctly, Dr. Leaf has his own place now. He isn't moving in next door to Mr. Driscoll. And we're going to do our job in resolving these 2 appeals. But I don't understand why this case has gone on as long as it has with the different lawsuits out there. So we do not want to discourage the parties from continuing to see if they could work this out amicably, and because this case has gone on too long. So we will do our role, but we encourage both sides to keep thinking about perhaps, because I know, I've been at this a long time, I know a lot of cases where obviously at least one party is very disappointed in the result of an appeal, but more importantly, there are cases when both parties are disappointed And any event, I've said enough. That concludes our, both this case, which is now submitted, and it brings to a close our hearing today. We thank both sides for their presentations. We thank the court officers and the clerks for their role, and we are adjourned.
All rise, please.
Thank you, Your Honor.
We'll stand at recess. Enjoy. I got it. All set. Ready? A+.
Thanks, Eric. Right back at you.
A+, A.